All right. I mean, I think that is satisfactory as, yeah, he had a source for this.
The next,
I have 341 to 341, I think 19 to 350, 17.
is that the whole BB?
Correct.
Yeah, that's not an issue.
Okay.
So that is out by agreement. Okay.
And then 356, 9 to 19 was the same issue, I think.
Yes, I think I have the full redactions, 341 line 19 through 350 line 13.
What about 356?
Yes, 9 through 20.
Yes. And Ms. Hilton, the next one I have is 361, line 1 to 362, 10. I don't know if we had agreed to that or not.
What I have as the final is that we were going to take out 361, part of line 16, so line 17, where it says Shannon shot up that tour bus.
Say the lines one more time.
Half of line 16 and a portion of line 17, the sentence reads Shannon shot up that tour bus.
All right, so that's out by agreement. There may be another part we need to take up, right?
Right, well, part of that, Detective Thorpe says, listen, this is 362 lines 7 to 10, which was included in my objection.
I'm sorry.
I guess the state doesn't agree with that. Detective Thorpe,
Oh.
listen, but you said a key piece of stuff we've been asking you. You said without a hesitation, without a doubt, Shannon the one who shot the gun. And then Kenneth says, y'all keep thinking I'm doing stuff. And I'm not 100% certain on the context as I sit here now, but it's right after discussing the Lil Wayne.
Well, what I believe is happening in this portion, Your Honor, if you go back to 361, Kenneth is elaborating that he's not the problem, it's Shannon. And so he goes on and he's saying Shannon is doing everything. Specifically, he says Shannon killed Nut. Shannon shot up that tour bus. Based upon prior ruling, we know that should come out. Then he continues to go on. And he's saying, I ain't retaliate one time, now I'm on 362. And then Detective Thorpe, I guess, is trying to clarify, I said, because you just said a key piece of stuff we've asking you, you said without a hesitation, without a doubt, Shannon the one who shot the gun. Because, and this will be speculation on my part, but I think because he's the investigator of the Donovan Thomas murder, that is what he is focused on. And then Kenneth Coleman doesn't even respond. He just says, y'all keep thinking I'm doing shit. I'm not doing nothing. I'm telling you, I'm fixing to go back to jail. I'm not trying to hurt anybody. Right. So he doesn't even respond to
All right.
Detective Thorpe.
So maybe we could just take that part out then?
It seems right. and it
The
seems-
Detective Thorpe part?
Well, without a hesitation.
Yeah, okay, so why don't we just take out 7 through 11? So 362, 7 through 11. Or 10 or whatever. 10, I guess. Okay.
Yes.
All right, next one that we have dispute about.
The next one we have this.
Yes, because y'all can spend your lunch break talking about the ones you agree on. And then you can come back and put it all on the record. I guess if you don't know, then we have to talk about it now.
Look at 365 lines 6 through 8.
$365. Yes, that's in this. That's in dispute.
Okay, so, Your Honor, on 365, 6 through 8, the context of this is Quindarius Zachary, also known as the other little dude, from Cleveland. He allegedly would buy, he's not a convicted felon, he'd allegedly buy guns.
Mm-hmm.
At some point, he bought a gun for Kenneth Copeland. Kenneth Copeland, allegedly, Kenneth Copeland ends up getting arrested. Then he wants to get the gun back, but then wants to get rid of the gun. And it's a gun that's later, my understanding is later, Kenneth is arrested for because he's carrying it to the Dunbar Rec Center and leaves it in the bleachers. Kenneth is saying that Jeffrey told Quindarius to buy the gun back from Kenneth. However, Kenneth was incarcerated throughout that period, is my understanding. So I don't believe he's speaking on firsthand knowledge. He's just speculating or passing on hearsay that Jeffrey instructed Quindarius to buy the gun back from Kenneth. I don't believe he has any firsthand knowledge.
So I have a different analysis. I believe that they are talking about initially buying the gun from the pawn shop. So if we go, but they're talking about the fact that Quindarius buys the gun, specifically most of the guns from Arrowhead Pawn Shop. And for the reason that Mr. Shard stated, the state believes because he was not a convicted felon, he would purchase a number of the guns on behalf of YSL
Go grab some
members.
juice
And what the detectives are saying to Copeland is you told him to buy
before
the gun.
this charge
And he
orders
said,
want to
no,
get back
thugs
because you're right
told
on
him
the
to buy
game,
the
John.
gun, initially. And then later on, there is some conversation about Mr. Copeland was arrested and he was going to try to sell the gun, which when he got out, and that's how he ended up.
Yeah, this looks like the buying it to begin with, not the buying it back afterwards.
Well, either way, Your Honor, I don't see any indication that it's anything but hearsay. And here's the other thing. Quindarius Zachary is apparently going to be called. So Quindarius Zachary would certainly have firsthand knowledge of who told him to buy a gun. And right now we have Kenneth Copeland on an out-of-court statement, possibly speculating or passing on hearsay. And it seems to me that we would have a live person on the stand that could answer that question pretty clearly.
My position would be is, one, if this statement comes in, it would be contingent upon us asking some foundational questions on the stand first. And then depending on what his response is,
Okay.
This would probably be a prior inconsistent statement, depending on what his answer is. I don't know what it will be, but we can lay more foundation as to
Okay.
when, how did this come about? How does he know Doug told him to buy the gun or not?
All right.
I would just ask that the foundation is laid.
Outside the presence of the jury. Yeah, absolutely. Outside jury. I just wrote that down. Okay, so we'll need some foundational questions on that. Assuming you can lay the right foundation that he actually knows it, then he ought to be able to say it. But we don't know that yet. All right. Hang on just a second. Miss Winfrey. Portion.
I believe there was a portion of, so page 375, line 17 to page 376, line 9. The state only had an objection to page 375, line 17 through 19. Defense counsel wanted that line out. That Mr. Copeland says Doug is connected to a lot of people. We wanted that portion in, but that was.
I don't have a problem with that. And then 375.
All right, so hang on. So all of 375-17 through 376-9, there's no objection to. Is that right? Is that right?
Yes.
Coming out, right?
Okay. Wait, coming out or staying in? Y'all seem to be
Agreeing that it
saying,
comes out. We're agreeing that it comes out.
Wait, hold on. 375 lines 1 through. You said 1 through 9, Your Honor?
no, I'm saying what you said.
Oh, I'm sorry. Yeah. I thought I
You
heard
said 375, line 17 through 376, line 9. Are you agreeing that all of that is in or all of that is out?
I think everything from 375-20 to 370. Everything from 375-20 to 376-9 is out.
Out, okay.
And I agree.
All right. All right, what's next?
I have 378, 1 through 8.
You said 378, 1 through 8?
Right.
Yes, that is.
Agreed, out.
No, that is in this.
Oh, okay. All right, tell me why that's in. Oh, I see, that's not the detective saying 7 through 14, that's Mr. Copeland.
Yes.
So then, Mr. Sharp, tell me why that's out.
Well, two reasons. First of all, it's speculation about what other people will say. And also it's a comment on individuals' right to remain silent. I mean, they're asking, if we call people in here, who's going to tell, who's going to give it up, and then he just speculates. And I don't think that's relevant. I don't think that's appropriate. So I don't know why it would be admitted.
What's the state say?
Your Honor, so this is a portion, if you look at right before, on page 377, the detectives are asking Copeland, specifically talking about the murder, who do you think we can call in, who will speak to us about the murder? And what Kenneth Copeland's response, beginning on page 378, line 1, put it this way: Thug and them already knew those four right there, they're not going to tell. He's talking about Yak, Nard, Shannon, and one other, and it's slipping my mind who's the fourth person. And he says, I don't know about doo-wop, but them niggas not going to tell. That's why they not saying it. You feel what I'm saying? I understand why everybody doing this stuff, but I at least want to make a way to be like, well, Woody told us. You feel what I'm saying? This is a YSL member who knows the individuals in which he is around. He knows who will come and talk to the police and who will not. And who will protect the enterprise. And that's what we believe he is telling them. Like, these people are not going to talk about our activities. So there's no use in you trying to speak with them, because they're just not going to talk. And Thug knows that they're not going to talk as well. As it relates to commenting on pre-arrest silence, Your Honor, I'm looking at an 11th Circuit case, United States v. Reeves, REEVES 742, Fed 3rd 487, which is a 2014 case. And
Sorry, just tell me that whole site again.
Sorry, and if I went too fast, I apologize. United States v. Reeves, 742, Fed 3rd 487.
Okay.
And the key holding that we have is the government may comment, and it's really on a defendant's silence if it occurred before the defendant was in custody and given Miranda warnings. In this case, at this time, none of the defendants were in custody at all. They were still investigating the homicide. At this point, no arrest warrants were even taken out. During this interview in June of 2015, warrants were not taken out until October of 2015 for the murder of Donovan Thomas. So this would not be commenting on any pre-arrest silence, Your Honor.
Okay. So aside from the pre-arrest silence objection, what other objections do you have?
Well, it's speculation, and it's also, I guess, relevance. Like, why is Kenneth Copeland giving why would a jury hear an out-of-court statement by Kenneth Copeland about whether my client will give a statement to the police or not?
All right, so y'all had pointed me as the objectionable portion to 379 lines 1 through 12.
No, 378. I'm sorry.
Okay. That makes a lot more sense. Okay. All right, I don't find it to be any kind of a pre-arrest silence kind of potential violation. And this is his opinion as to how strong they're going to be with backing up and keeping silent about what the gang is or is not doing. I think that that's permissible for him to say. I don't think, I mean, It's only speculation to the extent that anybody's opinion about anybody else is speculation, but it's valid to come in. So I'm going to permit that in. What's next?
The next portion that I have as in conflict was page 386, line 20 through page 387, line 12. And
Is that in dispute?
yes, yes, Your Honor.
Okay.
I don't have me as, I don't have the dispute quite as broad. I just have the dispute over 387 lines 6 through 13. And it's just simply hearsay.
So, Your Honor, the state would say that this is not hearsay. We're not offering lines, page 387, lines 6 through 12 for the truth of the matter asserted. When you go back to page 386, Mr. Copeland, I think it's around here, he starts to explain that he never had an issue with Donovan Thomas, like that they've had conversations with each other. And some of the subject of that conversation was Mr. Copeland's relationship with Mr. Thomas's brother, Kelvin Watts. So when you get to page 387, lines 6 through 12, he's telling them about a conversation that he had with Mr. Thomas prior to his death. Now, whether or not Mr. Thomas said, I'm going to go holler at them, or whether or not Mr. Thomas did go holler at Kelvin, is not what we're offering it for. It's solely being offered for the fact that they engaged in conversation that was amicable prior to his death. And so we're not offering it for the truth of the matter asserted.
All right, so it's on 386 where he's talking about actually having the conversation with Mr. Thomas, right?
Yes.
Okay, and that's fine. That's not objectionable to the defense. So the part that they're objecting to is the part where, I guess, who is it that's walking up and saying this? Shannon, right?
No, so when we go to 6 through 8,
Yeah.
he's saying that Shannon was right there in the presence when the conversation was happening.
And it's Shannon who says, if I'm understanding it right, man, what's up with you and Kel, right?
No, it's Donovan Thomas.
Oh, and he was like,
And he's referring to is Donovan Thomas. So,
And I agree with her.
okay, all right. Okay, and so you're not offering it for the truth, you're offering it for the fact that Kenneth Copeland and Donovan Thomas are cool with each other.
yes.
All right.
Well, I mean, that already comes out in 386 that they had a conversation. My objection is when Hennett says what Donovan Thomas said, allegedly said, which is, man, I'm gonna holler at N-word and I'll let you know what's up. Because it's giving the impression that, and it is coming in for the truth of the matter asserted, that that Mr. Thomas was playing the role of peacemaker.
All right.
And
So I'm sorry, I don't mean to interrupt, just for purpose of keeping the record clean. So now what we're really talking about is just lines 10 through 12 of 387, right? Okay. So in that, they're saying, hey, man, you got to be offering that for the truth.
I mean, they make their point without, the point that they're claiming to be trying to make is made without that last part.
But sure, I think that gives context when you continue to go further down that page. And when he says, that's what Nut said. And then Kenneth says, yeah. So when me and Kel seen each other, I believe he says, when me and Kel seen each other at the skating ring, Kel was like, well, he wanted to see what Thug got to say. So I called Kel on FaceTime.
Okay.
But give us some more history. In the week leading up to Donovan Thomas's murder, there are a couple of events that
Yeah,
occurred.
I actually am already familiar
Yes,
with the
so-
skating rink event.
So it appears that on that Sunday, Kenneth believes, based upon his interactions with Donovan, that him and Kel are cool. And matter of fact, they actually do talk and have a conversation. And then the next day is when Kenneth Copeland gets beat up at the skating rink. So all this is in context of what is happening or developing those days leading up to Donovan Thomas's death. So I think it puts the second part of this page in context.
Oh.
But the only way it provides context
Is if it's being offered for the truth. Right. I was about to say, so now you're conceding it is being offered for the truth.
Not whether or not he hollered at him, but the fact that they just had this conversation, whether or not, because we don't know if he hollered at him or not. We just know that something may have occurred, then they saw each other the next day. Donovan might not have ever talked to his brother that day before. We don't know. We're not saying. He definitely went and spoke to Mr. Kelvin Watts once he left that meeting. We don't know. We're not offering to say he did talk to him. We don't know. What we know is the results, whatever that conversation was, there was an amicable meeting between Kelvin and Mr. Thomas that Sunday
Even to the
before.
extent of the discussions about his own brother, it was amicable.
Correct.
And
Whatever.
it-
Whatever.
Okay. But not for the truth of whether he's actually going to holler at him.
Right.
All right. Well, that seems like it's then not offered for the truth. So, all right, that can come in. All right, let's take a lunch break. I know the lunch is here for the defendants, so let's be back. Will it be enough time, you think, to get everybody fed to come back at 12:20? Not 12:20. No, that will not be enough time. 1:20? 1:20, will that be enough time? I'm asking the deputies. Yep. 1:20.
Yes.
My bad, chat. I had to go get that thing. Now come on. We gotta get the, you know what I'm saying? Chat. Let me check. See how long I've been. Oh shit. How long they going, chat? I said I was gonna be done in 20 minutes. 104. Just about. Just about. Now what we gonna do right now is be real. What we gonna do right now is because they got the verdict out for the stabbing trial. What we gonna do is take a look at that. I already had y'all ready, chat. I already got you ready, chat. You know what I'm saying? I already got you ready, chat. Ah, shit. I wasn't ready for that, chat.
Court authorized your arraignment. Would the jury and the defendant remain standing? All others be seated, please.
May I inquire, Your Honor?
You may.
Members of the jury, have you agreed upon your verdict?
Yes.
Yes.
Thank you. Mr. Officer, can you please have the verdict slips?
Let's see what it is, chat. Let me know. Y'all think she going or not? That's the real question. Do you think she's going or not, chat? Do you think she's going or not, chat? That's the real question. Finally, YouTube. So it looks like YouTube has been up for an hour. So anyway, that just happened to the YouTube.
What say you,
Appreciate
Madam
y'all.
Forelady, as to indictment number 2183CR00153 on offense number
Yeah.
001, wherein the
Been on
defendant,
for about an
Christinne
hour.
Ricci, is charged with the crime of murder. Is she guilty or not guilty?
Guilty.
Guilty of what?
Murder in the second degree.
Thank you. As to offense number 002, wherein
Oh
the
shit,
defendant,
let's
Christinne
smoke one of
Ricci, is
that.
charged with the
Cause
crime
they
of
smoked her.
assault and battery by means of a dangerous weapon. Is she guilty or not guilty?
Guilty.
Your Honor, may the verdict be affirmed.
Yes, they may.
Thank you. Members of the jury, hearken to your verdict as the court has so recorded it.
Oh shit,
You,
bro.
upon your oath, do say that the defendant,
Oh
Christinne
shit,
Ricci,
bro.
is guilty of murder in the second degree on indictment number 2183CR00153, offense number 001. So say you, Madam Forelady.
Guilty.
So say you, all members of the jury.
Yeah, it's over.
You further, upon your oath, do say that the defendant, Christinne Ricci, is guilty on indictment number 2183CR00153 on offense number 002 on the charge of assault and battery by means of a dangerous weapon. So say you, Madam Forelady.
Guilty.
So say you, all members of the jury.
Guilty.
Thank you.
Then they got her guilty on everything?
Jurors, you may be seated.
Is she guilty on all three charges? Oh man, she better hope they run them
Jurors,
shit
I want to thank
concurrently.
each of you for the time that you have spent with us on this important matter and resolving this important matter.
Bro, she better hope they
As
run
I
them
said
shit
to you in
concurrently,
closing
gang.
remarks yesterday, you should have confidence in your abilities as jurors.
Not consecutive, concurrent.
I
Put them
know that
bitches
being a
together.
juror is a very difficult thing, and I
Mhm.
appreciate all the sacrifices that you've made to be here and to resolve this case. And that includes the deliberating jurors and the alternate jurors. I'll be back in the jury room in a moment to get your feedback with regard to the case. I like to hear what we're doing well as a system for jurors, and more importantly, how we can improve our system and make your experience easier and better. So I'll be back to greet you and give you my personal thanks. I now lift off of you those rules. Your jury service is completed. And you can now speak to anyone about this case or no one at all. You can do any research you want about the case or none at all. And I'm supposed to tell you that you can now leave with not open minds or closed minds, but I hope and I know that you will go through your lives open to new people and new experiences. I'll be in the back in a moment. Thank you.
Court, all rise to the jury. This way.
Be seated.
I know you've had no time to speak to the victims with regard to the case, but what's the Commonwealth seeking with regard to sentencing? When is what I'm asking. Or do you want a moment to speak to the victims?
If we could have a few moments, that would be great. I know Attorney Tim Bradle has been representing the three Ricci children. I just need to make sure that, is Your Honor inclined to potentially do sentencing today, or are you asking for?
I actually would prefer not
Yep.
to do the sentencing
Okay.
today.
Something's
But I
just going
will
on
do
with
the
my mic,
sentencing
'cause
today, or
I
at
don't
least I
know,
want
I
to
don't
take
know
into
that.
consideration what the
But it
victims'
looks like we got
views
another
are with regard
sentencing
to
going on,
that.
so we're gonna
Okay. And,
Before I make a decision.
child custody
Does the
murder
defense
trial.
wish the sentencing to go forward today?
Hell nah.
We have two members of my client's family that are here from out of state, so it would be better that it be done sooner from our perspective.
Hell nah.
But
She going to custody today though.
also we have, presumably though, there is some advantage to perhaps having the children here and giving them an opportunity to speak. So I leave it to Your Honor.
Why
I don't
we
know
get a
what's
little
been
more
going on
information, before we
with they
decide
mics,
how
bro,
we're
but
gonna
these shits
proceed
is low.
today.
You know what I'm saying?
So I'll take a break. I'm going to speak to the jurors and send them on their way.
Thank you.
Anything else that we need to do at this moment?
No, Your Honor.
Thank you.
All rise, please.
Okay. I don't think this one has started just yet. Yep. Took her right into custody. I told you she going right into custody. Once you guilty, boy. Put them hands behind that back, man. Okay, chat. What we're gonna do is jump over to this here. I don't think it actually. It's supposed to be sentencing. It hasn't actually started yet. Okay. They said it was up and going, but I guess not. You know what I mean? I guess not. Okay. I really wanted to watch this 1090 Jake video about the studio situation. In the meantime, That's what we all do, actually. That's what we gonna do, actually. Right? For sure.
Hi, we're visible.
You ain't doing that.
To another episode of EOS. It's 1090 Jake. Man, I'm rocking with y'all, and y'all rocking with me. And for this video, we're going to be speaking on the major update within the Julio Fulio case and the arrests that have been made. Now, this was a drill unlike anything we've ever seen.
Jake.
4K surveillance video of the shooters, cinematic rainfall, this action figure looking ass dude. I mean, the production was so damn good it looked like Drew filmed it. But the reality is, the Julio Fulio hit will go down in history and sadly will take more lives than one. June 26th, 2024, only 3 days after Fulio was ambushed, Jacksonville sheriffs observed a gold SUV speeding with dark tinted windows. Patrol lights were activated on the unmarked sheriff's vehicle and a traffic stop was conducted. The driver was identified as 18-year-old Sean Gaithright. The smell of marijuana was coming from the vehicle, but Sean denied having or smoking any. Sean would be asked to step out and would stand at the back of the vehicle while the deputy searched inside, finding a small bag with marijuana residue and mushrooms. A Glock 19 would be found in the center console, and in the back seats would be several bags of ammo along with firearm parts and accessories. Sean would be arrested and taken into custody, where he was taken to the Crime Gun Intelligence Center office for an interview. The very next day, Jacksonville sheriffs received actionable intelligence in reference to a conspiracy to commit murder. Based on the new info, a search warrant was obtained and immediately executed. Detectives arrived at a home located on Jacksonville's north side. They'd been informed 21-year-old Isaiah Chance, 21-year-old Alicia Andrews, and a baby were inside of the home. Surrounding the house, detectives began giving verbal commands over a PA system for the next 15 to 20 minutes before they surrendered.
Isaiah Chance, this is the Jacksonville Sheriff's Office. We are in your front driveway.
Damn, what kind of camera is
that?
that?
Warrant for your arrest. Come to your front door with nothing in your hand. We are not going away.
I gotta update my cams.
Things would go quiet.
I gotta update
Monday,
my cams.
July 29th, 2024, the Tampa police chief, along with the sheriff of Jacksonville and the Hillsborough County State Attorney, announced 3 arrests in the death of Charles Jones, aka Fulio. Alicia, Isaiah, and Sean were all being charged with first-degree premeditated murder, which under Florida law is punishable by death. They'd also be charged with conspiracy to commit first-degree murder, but Sean, the youngest of the 3, would face additional charges. And by additional, I mean 3 counts of attempted premeditated murder with a firearm and tampering with physical evidence. 2 other men would be named and listed as wanted for murder. 30-year-old Rashad Murphy and 27-year-old Davion Murphy. The 2 cousins and Sean are accused of being the 3 shooters who ambushed Fulio's car, leaving him dead and 3 others injured. They'd be captured on hotel surveillance along with cameras from a parked Tesla. On the day of the murder, Isaiah and his girlfriend Alicia tracked and followed Fulio to 2 separate locations in Tampa. At each location, they got out of their vehicle and Isaiah used the cell phone. After the cell phone communication, suspects in a second vehicle arrived at each location. Both vehicles then followed Julio Fulio from a club to the hotel. One of the vehicles would drive by Fulio's parked car twice, seemingly confirming which car he was in. Then, 3 armed shooters exited their vehicle and opened fire, killing Fulio
really
with
see
the
the
handgun
shells shooting
and
out
2
that
rifles. Surveillance. 3 armed shooters exited their vehicle and opened fire, killing Fulio with a handgun and 2 rifles. Surveillance footage, license plate readers, and car logs would identify 2 vehicles to the suspects. Law enforcement is well aware Julio Fulio was from 6 Block and rivaled rapper Young and Ace, who was ATK. ATK being short for Aim to Kill, or Ace's top killers. Come to find out, Isaiah is a documented member of ATK, while the Murphy cousins are documented members / affiliates of another gang known as 1200, with both ATK and 1200 being allies. The war between the two gangs has been going on well over a decade, resulting in dozens of murders on both sides, and now law enforcement believes all of the listed suspects work together to track and kill Julio Fulio. Isaiah would be more commonly known as Gutter Zay, and his one and only rap video would eerily resemble the night Fulio was killed, even though it was recorded 10 months prior. His girlfriend, Alicia, is rumored by fans to have been one of the females at Julio Fulio's Airbnb party. Tuesday, July 30th, 2024, with the help of U.S. Marshals, Jacksonville sheriffs were able to locate Rashad Murphy in an apartment complex in southwest Jacksonville after midnight. SWAT would arrive at the scene as it was now a standoff, with Rashad refusing to come out and allegedly on FaceTime with his girlfriend with a gun to his own head. Rashad would eventually surrender and be placed into custody, and at this time, only Davion Murphy is on the run. As far as Sean, not much is known about the 18-year-old, but what is known is in his arrest report he was arrested for speeding, found with drugs and a gun, and was transported to an interview room. The next day, Jacksonville sheriffs received actionable intelligence in reference to a conspiracy to commit murder. Now it's too early to know for sure, but for Sean to get arrested for something unrelated, and the very next day sheriffs have enough info to grab Isaiah and Alicia, it sounds like Sean may have already folded in the case. With him being the youngest involved and now accused as being a shooter, it wouldn't be that hard to imagine, but we'll just have to wait and see how the case plays out. Now in the beginning of the video, I told y'all that the Julio Fulio hit is going to take more lives than one. And what I mean by that is, they're not going to get out of this situation. I don't like it. Apparently, allegedly, there's been a lot of unfollows regarding the people that have been arrested. I'm not going to get into who unfollowed who because the police are going to put all this shit together. And the amount of evidence that a lot of people on YouTube are trying to put together, like, oh, this dude's not in this gang, he's really in that gang. Let the police figure that out. You don't have to do it for them unless you're really just trying to get a badge. Let them figure it out. They're saying one of them is this gang, let it be. They're saying this is how it happened. No, this is how it. Let them figure it out. We don't have to piece it together. We piece it together when we get the paperwork because that's what they got. We're not giving them new information. We're using the information that they got. But I'll say this. Seeing everything we've seen and not even getting into everything that they have as far as the police, I don't see them getting out of this situation. I don't see them, for one, having the money to fight this case. For two, the cell phone logs that they're about to put together are gonna trace them all the way from Jacksonville to Tampa to each location Fulio was at, and then obviously leading up to the murder. It's gonna be similar to the YNW Melly case, how they were able to use T-Mobile to track his cell phone location. They are able to tell when your vehicle is stopped or moving. This case is gonna be, I don't want to say quick. I can just imagine that some of them are going to try to plea out early. In order to do so, they're going to have to snitch, going to have to cooperate. Some of them are going to get fucking punished. And there's going to be no leniency. There's going to be no plea. It's going to be straight up life sentence.
My name is Judge Whitaker.
Now,
Judge
premeditated murder,
the judge presiding
you can
over
get
this case for
executed
which
in the
you have
state
been
of Florida.
selected and sworn to try. I will be the presiding judge in this case moving forward. You are not to concern yourself with this change. And I propose to say And to calm any concerns, Judge Glanville is fine. Because if I don't say something like that, they're going to be like, oh my God, did he have a heart attack? Or, so that way nobody's searching on the internet. Okay, then let me remind you, as I assume presiding duties in this case, that none of my decisions and nothing I say during the trial is evidence, just like none of Judge Glanville's decisions and nothing Judge Glanville said during the trial is evidence. The decisions and remarks of a judge do not mean that the judge favors or leans to one side or another in the case.
Make that clear.
I am only interested in seeing that this case is tried fairly based on the laws and the Constitution of the state of Georgia and the Constitution of the United States. You are to disregard any comments that may have been made by Judge Glanville about any of the lawyers in this case. To maintain the dignity of the jury system, I remind you that you must decide this case based only on the evidence admitted during the trial and the laws I will explain to you. Thoughts, objections?
He ain't playing with it. That's how it looks.
Consistent with what Mr. Ray
Turn his mic up, guy.
yesterday, which I know is part of the file, we would object to. I think that it's important not to say that don't worry about it, Judge Glanville is fine.
Okay, well, I just mean, if you want to come up with another way to say that, that's fine. Do you not want to say anything at all? Just.
I'd like to say what I wrote. He's been removed from the case. That's it. It's not disparaging. It should be disparaging, but it's not. It just says he's been removed.
Well, he is no longer the judge presiding over the case.
Got it on.
I think pretty much says that. All right.
Can I also ask just a procedural question?
Mm-hmm.
Again, shout out to everybody on YouTube, everybody on the Rumble, everybody on Twitch. I appreciate all y'all for tapping in. Now I'm saying respectfully.
It is not yet because it was the rough. Are you talking about of the ex parte? No, when Ms. Weaver sent it to me on request, she said at the time, this is still rough. So as soon as it's ready in final form, I can ask her to file it, but it's not yet.
Okay, thank you. It's just that we've been referring to it.
Sure.
In an appellate court opinion.
Now, it will get in the record.
Thank you, Your Honor.
All right.
Your Honor, with respect to the instruction that you are to disregard comments that were made regarding any of the lawyers, the only concern I have is that, of course, the judge ruled on objections, and in the ruling, I don't know if anyone could perceive any of that as comments. I know it's kind of silly, but it's plausible. And I would ask that the court, with respect to the pattern or the altered pattern instruction, instead read the decisions and remarks of a judge do not mean that the judge favors or leans to one side or another in the case.
Mm-hmm.
The court is only interested in seeing that this case is tried fairly based on the laws and the Constitution
This is how you know
of the
this.
state of Georgia
This
and the
whole
Constitution
trial
of the United
petty.
States, rather than
They arguing about her remarks
Is
about
that
Judge Glanville.
the change you're talking about? Instead of saying I am, say the judge is?
Correct. That, and instead of saying disregard the comments that the judge has made, instead read the decisions and remarks of a judge do not mean that the judge favors or leans to one side or another.
So you're saying just say that, don't say disregard.
Right.
Okay. I'm overruling that. Okay.
Thank you.
So neither side's happy, so that probably means I did a good job.
So the court, is the court considering, instead of saying I am, saying the court is? I didn't know.
That's fine.
Okay.
I don't think that's a particularly substantive change.
You know what I'm saying? Told you, they arguing semantics right now, wordplay. You know what I'm saying?
So that takes care of that. And
I think I have to turn the lights on.
we were on I think we had finished the 387 lines 10 through 12, and we hadn't moved on to the next thing. So let me know what the next portion is.
Yes, Your Honor. We will actually have to go back a little.
Okay.
Mr. Shard and I had the ability to meet
Okay.
during the lunch break, and we did discuss those redactions that we agreed with, and there were a few early on that we realized we still disagree with. So
Okay.
the first, Your Honor, is page 266, lines 14 through 24.
Yeah, is they ever gonna talk about that other ex parte meeting that wasn't brought up? I know they was talking about that last day for. Or did they take the day off to get all the transcripts and all that stuff out? Because today it seemed like court started late. Like court was already going before the cameras got on.
Okay.
You know what I mean? So I don't know.
My thing is,
I don't know.
my belief is that this goes back
I don't know.
the issue of hearsay about what he believes, quote unquote, Doug, Mr. Williams, said to other people. And so really the key part of this is the last section. So Doug was like
Yeah.
that gun, you know, and it just
It looks
we need to know if
that, yeah, that's definitely nothing but hearsay at this point, and we have no idea. So that we need a foundation. And that also outside the jury. Agreed. All right.
Your Honor, next, page 270, line 4 through 18.
Court smart's operated by our court clerk, Sue H. Our official court reporter is present. She is the official record. The court smart recording is not available for release. I'd ask counsel to please enter their appearances on the record.
Good afternoon, Your Honor. Christine Lento, appearing on behalf of the state. Assistant Prosecutor Jamie Sherman for the state.
We chill that out for a minute.
Well, I can't
So
say
what is going on?
but previously stated that Mr. Copeland's statement said Shannon was in possession of the gun would be admissible over my objection.
Mm-hmm.
I think this falls under the same.
Okay. So you're just making the objection to this part as well. All right. Thank you.
Yeah, thank God for subtitles. Cause they ain't have none, bro.
So then next, Your Honor, I think we're back on track, and we're
Okay.
at page 389, lines 1 through 17.
Yo, is they going through the whole 1,000-page shit they were talking about that? Hey, we only on 389. We got like another week of this shit. Come on. I'm with the judge now. Let's get productive. Let's get productive.
Let me read it. Give me just a second.
Bro, ready. Spelling bee champion, avid reader. That guy right there. Nickname Ready for War.
Okay.
So if you go to just the last line of 388, just back it up.
Yeah.
It says, they're asking who's talking about the Donovan Thomas case. And he says, I never heard Shannon talk about it.
Mm-hmm.
He says, I heard Nard talk and laugh about it. Know what I mean? And he doesn't say what Nard said. So there's
Right.
there's no statement. The fact that I've heard Nard laugh about it, we don't know the context of it, but that may be admissible against Nard, his name is Demise McMullen. He's on the indictment, but he's not sitting here with the rest of these gentlemen here today.
Mm-hmm.
So we think it's inappropriate to talk about how Nard has reacted or Demise McMullen has reacted to this.
Can I ask, so it's either in evidence or going to be in evidence, all of the people that the state alleges committed this particular alleged crime, right? I mean, the jury's gonna know they think Nard did it, that they, the state, think Nard did it?
Well, I would say the state thinks Nard did it. The state in their opening statement has stated as much. I'm standing by my objections about Kenneth Copeland's testifying about what Mr. Darlington said. But that's their stance, that Nard was there and involved in the car. But, so yes, I would say that's their theory. I don't know what the evidence is going to show or how strong the evidence is going to be, but again, his reaction to this and laughing about it is prejudicial to our clients and irrelevant because he's not sitting here with us.
All right, I'll hear from the state.
Your Honor, we do allege that the person he's referring to as McMullen is a member of YSL and one of the individuals who shot and killed Mr. Thomas back on January 10, 2015. And so what precedes this conversation or this portion of Mr. Copeland's, what he tells police is that they ultimately brag about the fact that they killed Nutt, either by laughing or Mr. Williams' sister. We believe that that's a person by the name of Max. We believe that she is an unindicted co-conspirator in the YSL gang enterprise. We have put in evidence already phone records of Miss White, specifically with the Little Wayne bus shooting, that she was in the vehicle following that bus, so actively being part of the enterprise. We believe there'll be a jail call that's going to come in regarding some comments that she made specifically about the murder of Donovan Thomas. Basically claiming that they were the ones responsible for killing Donovan Thomas. And so these statements corroborate that ability for this gang to be cohesive regarding a crime that they have committed, and talking about it freely amongst themselves, we believe would show cohesiveness with the gang, would show, and that would be in furtherance of this gang.
Is that yet got it?
Okay.
Now I understand that the state is, the argument for admission is A1B2E. I don't understand how states arguing that Nard, according to Mr. Copeland, saying, laughing and saying, man, F that B, furthers conspiracy in any way. We don't know any of the circumstances around when he supposedly said this, who was around, or how that would be speaking for anyone other than Mr. McMullen himself. And then when we get to Max, who she allegedly said something about, and I guess this was afterwards, according to Mr. Copeland, I don't know. You better not play with my brother. We're really leading to the conclusion that these are statements in furtherance of conspiracy. These seem to be individual statements, just what they think about things. I don't know, maybe Max doesn't like Mr. Thomas, maybe Max does like Mr. Thomas, was mad, but Max is not, it's not a statement by a co-conspirator, it's not furthering anything. Max and Nard do not speak for Mr. Stillwell. Mr. McMullen laughing is not an indication of how Mr. Stillwell feels about anything. And neither of these two individuals, Max or Mr. McMullen, are seated here today. So I don't know why it would be misquoted.
Okay, so, well, because it's alleged to be a gang and it's alleged to be Rico. And I mean, it's, you know, kind of good in contrast that your client never laughed or said a thing about it. And these people are, you know, it's not true. And you can point at somebody not here if you want to or not. But I think under the state's theory, and given that you're telling me evidence that these people are going to be shown to, at least by a preponderance, be part of this gang or associated with this gang, and this is kind of bragging on the gang.
Well, Your Honor, regarding the association with the alleged gang, I just want to make sure I'm clear. Max is not indicted.
Right.
She's not charged.
No.
Really, this is the first time I'm
hearing that she's an unindicted co-conspirator?
Yes, I've heard her on help calls, talking with people, but I don't believe I've ever heard that she's an unindicted co-conspirator.
Now you know.
That's crazy.
And I believe he did during the entire Lil Wayne bus shooting.
Mr. Steele corrected me and said that they have.
Okay. All right. So, yeah, I'm going to let that in.
So they just sprung up another co-conspirator.
Part A, we're complete. I know Part B is probably going to be handled by Mr. Adams, I think. So we have
Another
Part A
co-conspirator.
and Part B. I don't know where you are now.
So Mr. Shar handled some of these redactions previously, and then Mr. Adams handled
Okay.
the rest of those redactions.
All right. Take it away, Mr. Adams. So give us the next portion we're going to be contemplating.
Let me hear you.
Go from page 413
Okay.
to the end of the transcript.
Ooh. That's a lot.
That was good news. And I believe that I'm really just going to be reciting to you.
Once you start reading, we're gonna go back to the other trial, see what the verdict is.
All right.
Just see if we can get it out the way. Cause she takes breaks in between just to read and shit. You know what I'm saying?
Sure. All right. So you're just going to put on the record the stuff that's agreed to.
Yes.
Okay. Sounds good.
While they're doing this, let's go over here.
Good afternoon, Ms. Lento. Good afternoon, Sean Mario. Good afternoon, Your Honor. Mario Belushi on behalf of Mr. Gregor.
Pages of
Thank you both.
lines.
Good afternoon, Mr. Gregor.
Might I
Mr.
ask
Bellucci, there is
if
a
it's already
pre-sentence
in writing
investigation report
anyway,
in
and
this
y'all
matter
can
prepared
sort out that you do agree
in
to it,
anticipation
if
of
you might
sentencing.
just
Did you have an opportunity
file it
to review it with your
instead of
client?
reading it
And
out
is it
for the
accurate for
next 20
sentencing?
It
minutes?
is, Judge, I have an opportunity to review. My client actually reviewed it with me in person this week.
Okay.
And it is accurate.
Okay. Well, you don't have to file the
Thank
emails,
you.
but maybe that
Mr.
might
Gregor,
be
you have the right to address me
an
regarding your
a better
sentencing,
use of our
sir.
time and
You have
easier for
45
you.
days from today to appeal the sentence. Exhibits by the state and a variety of letters which I'll discuss in
y'all, okay.
detail.
Let me just make sure we agree on one point.
Okay, let me just hear what you have
Detail
to say
later.
now.
Mr. Gregor, sir, is there anything you'd like to say about yourself or your case?
Yes, Your Honor.
Please go ahead.
Just want to say thank you for the opportunity to speak today. And Brianna, we haven't talked since Corey passed away. With everything that has been said, I just want to tell you that I'm sorry that you lost Corey. He was, to say simply, the best. I know we'll miss him for the rest of our lives. And the 2 years that I knew Corey were very difficult, but they were the greatest years of my life. And he was a happy, energetic, loving, radiant young boy who flourished in his life in all aspects the last year of his life. And sorry. That will be how I remember him. And Corey, wherever you are, I just want to say that I'm proud of you. Everything that you did. The last months of his life, us three, Brianna, Corey, and me, we spent more time together than apart. All those hikes and walks, trips to the beach, time spent playing football and all the other sports, going to Sky Zone, the park, the playground, sledding. In all of that, I saw how much Brianna loved Corey, how much he loved her, and how well we could co-parent together. Those memories and all the good times, they'll be what I remember, and they helped me get through the tough days. And I hope that they can help you too, Brianna. I'm sorry you believe I could have done this to our son, and it pains me to know that you view my actions those months together as ingenuine, that I could have hurt the most important person in my life. What happened on March 20th was inexcusable. To you, Brianna, your family, and mine, I want to apologize that you had to see Corey treated that way. He never deserved it. I understand this single moment will overshadow all of the others, but it's not representative of who I am, who Corey was, and his relationship with me and him. I want to assure you that on April 2nd, I did nothing to cause Corey's passing. I didn't hurt my son. I loved him and I still do. I regret not bringing him to the hospital sooner. I didn't know how sick he was. I didn't know. I just thought he was tired. And whether you believe Dr. Bodden or Dr. Andrews' version of the events, the outcome is still the same. Corey is gone. He had so much to give this world, and he still can. What we do in his memory, for his memory, things that he would want us to do, that's all we have now. To the court staff, sheriff officers, to the jury, and to you, Your Honor, thank you for being professional through this whole process. I understand you have a job to do today, Your Honor. Sentence me for the crimes I've been convicted
outlines of what we have agreed to in terms of the redactions. There is one portion that we may or may not have agreed on.
Okay.
And between checking the transcript of that and also just talking, we can go ahead and resolve that. We don't have to do that right now.
That sounds good. All right, so, and you can just file, I mean, it doesn't have to be in email form. You can just print out, here's what we've agreed to, and file that.
I'll do that.
All right, so what's our next statement we're moving to? Apparently. Mr. Adams got the easy part. Wow.
So we have the statement on the 21st.
January 21st?
February 21st, 2015.
Okay, right. We've got January 11th, January 28th, February 20th, February 21st, and June 10th, right?
Right.
So this is February 21st.
Yes.
All right, let me get that transcript, and y'all can switch to that video to the extent we might need to ever watch a portion of that video.
I ask that you could please consider all of the evidence presented in and out of the courtroom when making your decision today. I ask you to sentence me fairly, taking into consideration my entire life, and not just based on the 12 days. Thank you.
Thank you for your comments, sir. Mr. Bellucci, anything further from the defense side? Thank you. And I'll defer to either prosecutor for the state.
Thank you, Judge. Corey was a beautiful 6-year-old whose life was taken from him, and there's nothing that I am going to be able to say that is more important than the facts that came out in this courtroom, and more important as to what the defendant did. It is difficult to think about the suffering that Corey had to endure both during his life and during his death. It is difficult to contemplate the fear that he must have lived with every single day, doing the little things in life and even doing the simple things every time that he was with his father, the defendant. Christopher Greger abused his son. He ended his life. And then he left him alone in the hospital to die.
The February 21st statement.
One can only imagine what was going through Corey's mind in those last moments. One could only imagine how scared he was, how confused that he was, how truly abandoned
Look at her face.
that
She
he
fell
felt.
in that shit.
And there is simply no...
Page 13, line 19, page 14, line 3.
Okay.
Do you have timestamps for when you said page numbers?
So this has 3:59:50 to 4:20, 4 o'clock and 20 seconds.
Okay.
All right. What's our issue?
Miss Hilton, I'm sorry, Miss Hilton. Could you say now that I have the time, I wanted to make sure we were talking about the same thing. What, page 13, line
19 through page 14, line 3.
we got different transcripts.
So is this with Detective Gaither starting? You have it in your mind. We can't do nothing about it.
Yes.
Is that a different transcript? I can email you what I got. I got whatever I got from Miss Weaver. Okay, Laura, can you? Yeah, no, that'll be crazy if we're not working off the same transcript.
No mitigation for those actions. Aggravating factor number 1 applies. The defendant's actions were cruel and depraved beyond the elements of the offense. In regard to the endangering, Your Honor, Corey didn't merely run on a treadmill and fall. He fell. The defendant bit him on the head, and he fell 5 more times.
He said bit him in the head?
In regard to the ending of his life, Corey suffered a laceration to his heart, but those were not the only injuries. He also had a lacerated liver and a bruise to his lungs. He suffered multiple injuries. While Corey was at the apartment, he vomited, he defecated, he endured suffering. While Corey was fighting for his life, the defendant took a selfie not even having the decency to put a shirt on Corey, while Corey's body was shutting down, the defendant ordered food. When Corey was going into cardiac arrest, the defendant was more concerned about the date that he had set up for that night.
Let me
the
pull
defendant.
that up. Can you tell me what date?
Is crazy if he did all that, man.
No, I'm
To your own son, bro.
the date of the transcript for this trial where the February
Don't shout me
21st,
out.
statement by Copeland is argued.
It is,
That's all I'm saying. Don't shout me out.
He didn't call 911. He didn't call a doctor. He didn't call an ambulance. He did nothing. And this added to the suffering that that little boy had to undergo. The defendant then throws Corey in the back seat of the car.
something that's not consistent with the transcript. Please just let me know it's not intentional. It's just I got too many transcripts going on. But my understanding of what we're talking about here is Investigator Gaither is prodding Mr. Copeland for information about who shot at him. And in this context, it is the February, I believe it's February 19th or 20th shooting that they're prodding information about and asking Mr. Copeland to tell them who shot at him and his child and his mother's child. And Investigator Gaither goes through an extended, I'm not going to say monologue because it is broken up, but she is attempting to extract information from Mr. Copeland, and she's talking about the need to protect the community, to keep babies safe, and just essentially makes an argument in that interview that would draw an objection, at least for me, if the state were to make the argument in closing arguments. So I don't believe, I think, the focus, if we're admitting these statements in part, if they are admitted, they would be because they're inconsistent statements by Mr. Copeland. And I don't know how that somehow opens the door to Investigator Gaither to give basically her, thesis on why her job is important and gangs are bad and the community needs to be kept safe by her and her coworkers. So that's our objection, 403, 401, and it doesn't fall under prior inconsistent statements.
Okay, I'll hear from the state.
Actually got a hole in the jar.
So previously, Your Honor, when Mr. Copeland was here in court, his testimony in court was essentially, and I'm going to paraphrase, I didn't care about snitching. I didn't care about telling on police. I didn't care about telling the police who did the crime back in 2015. And so this portion of the interview was in contradiction to what he was saying on the stand, because in these 2015 interviews, especially early on, January and February, he would not tell the police who shot at him and his child. And so this portion of the transcript, he's explaining, if I tell you, you can't protect me, you can't do anything. And so Detective Gaither is having a conversation with him about some of his concerns, because this interview, Your Honor, is immediately the day after his first interview regarding this shooting. So he's interviewed on February 20th, and then either in the morning hours or late at night, he's arrested on a probation violation. And then he's brought back in again to further, they're trying to find out who shot at him and his children. And he has extreme concern about telling the police who shot him, actually admitting to that. And when we were in court, his testimony in contradiction to that was, one, that the individual that he eventually says shot him didn't shoot him. He says that in court. And then he also says that he wasn't concerned about snitching.
Meaning, I didn't have any problem with that. I was happy to tell them what happened.
Yes.
Okay.
And so
if he testifies consistently to that, or if y'all decide that you're going to stipulate to any part of the testimony, then this would become relevant as a prior inconsistent statement.
Yes, Your Honor.
Okay. All right. But that wasn't the objection from Mr. Sharp.
So even in going to I give that context because their conversation here is the effect on him, what she's trying to tell him in order to get him to actually tell her who's the person who shot him.
Right.
So we're not really worried about her. We're not offering her commentary for the truth of the matter asserted, but we're offering it for her, what she's saying, the effect that it has on him in order for him to come forward and finally tell who shot at him.
Mr. Sharp, I'll give you the last word.
Well, I mean, I understand the state's argument, but I don't think necessarily the need to provide context opens up the door to investigators just going in long.
Okay, well, I mean, it may be that there are other portions of this that we're going to take up. Right now, I'm looking at 13 line 19 through 22, and then basically 14 lines 1 through 3, where she's saying essentially, hey, buddy, you got to tell us what's going on, which is pretty much the beginning of any conversation, interview, interrogation between the police and anybody. And it shows that Mr. Copeland is very hesitant to do that. And so if he ends up testifying, man, I don't have any problem with that, then this, I would think, can appropriately come in as a prior inconsistent statement. I don't see any real other kind of like 403 or anything issues with it. So this is in, assuming obviously the foundation for getting it in as a prior inconsistent statement is laid.
So the next portion, Your Honor, is page 25, line 15 through page 26, line 3.
Okay.
Timestamp 40840 to 40940.
And Your Honor, last time we discussed these, this one, the one we just discussed, the one we're just about to discuss now, and the next one we discussed all together because they're the same issue.
Okay, well, I'll look.
And you, I think you'll see, I hope you'll see that that Gaither says more and more, investigator says more and more. They're all the same issue.
Oh, all right.
Man, it look like he tired of it. Look, see? Nah, we're gonna go back here.
Where he is left all alone. When the defendant gets to the hospital, he tells the staff not to contact Corey's mother. While he's on the phone with Corey's mother, he does not tell her.
Right, line 15 through 26, line 3?
Yeah, it's probably more like line 7.
Yeah, okay. That's what I thought. This one looks okay also to me. I am going to let this in.
Yeah.
I mean, she doesn't seem to be saying we're the heroes. She seems
Right,
to just
I'm
be
on
saying, "God, tell me something if you want it investigated."
All right, so,
All right,
Yeah,
what's
I can
our
hear you.
lunch break? I did
Page
not get a
28,
chance to do
lines
any of the
7
things
through
that I told
14.
y'all I was going to do. However, one thing I did do was
No, I'm gonna be out there
work on
tomorrow.
the further revision of the jury instruction. I saw that the state had sent over a couple of different proposals,
And for the time
and
of
I
14,
thought
Wait, was you talking?
part of those were good. And I'm just going to tell y'all, I'm just going to read out what I've come up with, which is a little bit from here and a little bit from there. Ladies and
Any
gentlemen, my
additional
name is
argument,
Judge
Mr. Shaw?
Whitaker. Judge
Oh, you can hear it
Glanville is
out?
no longer the judge presiding
Yeah,
over
I'm
this case for
streaming
which
the
you have been
YSL
selected
shit
and sworn to
and some
try.
other stuff.
I will be the presiding judge in this case moving forward. You are
Buddy
not to
shit breaking
concern
up bad as
yourself with
fuck.
this change. And I propose to say, and to calm any concerns, Judge Glanville is fine. Because if I don't say something like that, they're going to be like, oh
All
my
right.
God, did he have a heart attack? Or, you know,
In
so
response, Ms.
that
Stone.
way nobody's searching on the
I think
internet.
it's the same thing. She's just trying to
Okay,
get
then,
That
let
nigga
me
said I'm in,
remind you, as I assume presiding
person
duties
who
in this
shot
case,
you.
that none of my
All right,
decisions
now,
and
if
nothing
she
I
ends
say
up
during the
standing
trial
up
is
in closing
evidence,
and start
just
saying,
like
look how
none of
great
Judge
the police
Glanville's
are,
decisions and
they
nothing Judge
love this
Glanville said
guy's
during the
baby,
trial
then
is
we'll have a
evidence.
different issue. But
The decisions
just
and
as a
remarks
part
of a judge,
of
the interrogation technique going through statement, I'm going to overrule that objection.
That part.
The next, Your Honor, is page 29.
Where this kid sound like my
line
boy
9
trying to sing it
through,
in auto tune.
I think I might have a,
This
I
shit
have
was
page 48.
like,
Of course it does.
yeah, that right there. My boy sitting on the curb smoking a hot one way out in the boondocks. I said my boy sitting on the
I think
curb
it's page
smoking a
29,
loud one way in the
line
boondocks.
9 through
Oh.
page 30, line 18.
That nigga right there by the by the entrance to tell the exit.
All right, and what's our issue?
That's not even
with
the exit.
this? Is this the same
Oh, you about to be done,
concept,
nigga.
or is this moving on to some other evidentiary issue?
Yes. And I believe Mr. Shar wanted it out initially.
Oh yeah. So you hitting like the roach list, but you actually put real weed in there. Mm-hmm.
Where Corey is. Not only did he end Corey's life, but he took away his last moments that he had with his family. And there is no mitigation for that. Corey did not pass
I ain't gonna
surrounded
hold you,
by
Lucky. You might have to
those
call
he
back.
loved, holding his hand, comforting him. He passed alone with strangers.
If the state is successful,
Why they got my boy Mike down
lays the
somewhere?
foundation for specific prior inconsistent statements. Our stance, my stance, I believe I stand for everyone, I speak for everyone here, is that if prior inconsistent statements are included on a tape, that does not necessarily mean that the state just gets to play the tape. What they play still has to be linked to prior inconsistent statements.
Okay.
And here we're just kind of going and talking about things that are not subject to these prior inconsistent statements. Of course, I don't know what a prior inconsistent statement is right now.
Right.
But I think that there's a lot of fluff in between.
Right. Okay. And is the state proposing to, I've got a prior inconsistent statement somewhere in this 30-minute interview. I'm gonna play the whole interview, or are y'all?
So the state's position, again, depending on what we do with Mr. Copeland's testimony, he denies, and I think that's what we talked about yesterday. What he says is, I spoke to the police, everything I said, but it was all a lie. I finessed it all. So we're at a position that I don't know if we have to go line by line, because his general statement here in court is, I may have said everything that you said I said, but I was only saying everything that I said because I was trying to get out of going to jail, because I was trying to get out of getting in trouble. I was trying to get out of trouble. And so a part of it is we believe that we don't have to now go line by line, looking at the Scudder case going, I think it's Scudder, I'm citing the wrong case, going line by line. But specifically as it relates to this portion, we asked him about being a snitch, and this is her trying to explain to him, you need to tell us. It doesn't matter if you're a snitch or not. You need to come forward. When in court, he says something opposite. He says something inconsistent with what he said in his interview.
Okay, so if he ends up saying, I don't know what I said before, but everything I said was a lie, then you can't necessarily just play everything he said. But if he says, everything I said was a lie and I just said it to get out of jail, and then you say, aha, this shows right here you were willing to go to jail and keep quiet, then that's a prior inconsistent statement to what, if we assume he says that on the stand. But no, you do not. I mean, it still has to be, and it may not be, it has to be like every line, but you can't play an hour-long video unless at least most of that video in some way is inconsistent to what he's saying on the stand. So I don't know if I can, I mean, this is pretty theoretical right now, but.
I think we just need to see what he says while it says a lot of we believe two things. Not that it's just a prior inconsistent statement, but he's also contradicting what he says. So he'll testify, at least previously, that he'll testify, they were trying to force me to only talk about thug. They were trying to force me to do these things, and that's incomplete.
That would be, so this would show that's not true. Okay, so yes, potentially then, I mean, obviously for all of this, we have to, but I guess what I'm asking is, Mr. Sharp wants to make sure that y'all don't operate under a theory that something in this, and I'm just making it up, I don't know how long the video is, but 30-minute video is an inconsistent statement. We can get the whole video in. Y'all know that, I mean, is that your position?
I think it depends on when he testifies.
Okay, so, yeah. Okay, so then assuming that, I guess we don't have an answer to that right now, but I would not think the entirety of something can come in just because one sentence in it is inconsistent. So for y'all's edification, that would probably be my position. However, assuming that all of this is going to get used as prior inconsistent statement because of whatever he says, we have to assume it for now, like that's why we're going through this, then what other evidentiary objection do you have to it?
Well, I mean, I just keep going back to the same question, which is if the purpose, my problem is all the talking that's, Mr. Copeland isn't really saying anything. It's all investigator gate, and I just don't really understand how we're just giving investigator, and I know Copeland says something, so I'm not trying to mislead the court about the transcript. You have the transcript. But I don't know how we're giving basically Detective Gaither the mic when the purpose is to be impeaching Mr. Copeland with his prior words.
Okay. Well, I mean, I think we got to have the context of what questions he's answering or relating.
To the extent that other people's words may give context.
So, I mean, I would think, that in terms of evidentiary issues, then assuming, which we're doing for the sake of this entire exercise, that it comes in as a prior inconsistency, then there aren't other evidentiary issues that would keep this particular part out, 29.9 through 30.18. All right. So what's our next stop?
I'm sorry. The next section is page 47, line 9 through page 48.
Aggravating factor number 2 applies. Corey was particularly vulnerable and incapable of resistance. And this goes beyond the elements of the offense. It goes beyond.
All right, what's our issue?
No, we're gonna wait on that. They're doing victim impact statements right now.
Okay.
I think
She just said she's fine with it being out.
right, I'm not sure. You said it begins at 47.9 on your transcript.
So I'm taking a note that I believe I got from.
He on his Twitter arguing with Shannon.
Okay, you're right, 47.9. Okay, I got you.
Okay. Next.
So the next is page 65. Line 1 through 5.
No one would have made him. I would have happily continued to raise my son alone with the help of my family. He had many opportunities not to do this to him. He is in this current situation due to his own actions, and every day he will have to live with this. He deserves nothing less than to experience the pain, suffering, and isolation that he inflicted on Corey.
Okay.
I hope that every moment he spends in prison is haunted by the torment of knowing he killed my child. I fear when Christopher Gregor gets out of jail, whenever that is, he will come after my family and I again. I fear for our lives. His twisted mind truly thinks that I caused all this and that he's in jail because of me, even though he's here because he killed him. I truly believe if he ever gets out and gets the opportunity, he will kill me.
Any memory about why this is objective?
Your Honor, Corey should be going into 5th grade in September.
I think it may have been the programs that were used that was confusing. I'm looking at the transcript.
y'all? Anybody know?
Of sentence. I don't know if counsel has anything else.
You previously asked for permission to play some video.
Yeah.
You wish to do that? Mr. Galucci, do you have something else?
Yeah, Your Honor, Mr. Greger, if you would allow it at this point, would like to address the court.
What's the state's position?
Your Honor, we would defer to the court.
So I offered you that opportunity earlier, and I don't want this to become. There's a.
Thank you.
Going through for anything Christopher indictable superior.
I am writing this victim impact letter and asking them
to refute topics that are outside the scope of this trial. So.
And when it comes down to it, the answer is, his answer, it comes down on page 65, line 5. It says, since they shot at their car. And when I hear that, in that context, it seems that he's referring to
They as in Shannon and
shooting at a car. I believe what Mr. Copeland meant by that was an incident where they were all shot at. But I just have a problem with this being played for perception of the jurors.
okay. All right, and is there a redaction that could be made? So what is it that you potentially want this for?
If it comes and it gives a lot of context. So Mr. Copeland, in this interview, this is now his third interview that he's had with the APD, his second with Detective Gaither. So, and excuse me, this is his fourth interview, and I'm saying this in context. In the January 28th interview, he talked to Detective Gaither about the shooting in the car with Mikion and Shannon with him. So when he's discussing right now in February that the only people he hangs out with is Little D and Shannon, and that the last time that he's really seen them is since they shot at the car, that's going back to what he's already talked to Detective Gaither.
All right, in this particular interview, have he and Detective Gaither just been talking about that particular shooting where the three of them were the ones who got shot at?
He's talking about collectively everything that's been happening since January 10th.
So no then? Like if you're the jury listening to it, you might be confused when it says they shot at their car.
But this is the only car incident that when you look at all the interviews.
All right, hang on. So y'all have alleged, I don't know how many different acts in furtherance of a conspiracy, and you've got 8 or 9 different incidents, I'm sure some of them involving cars, where people are getting shot. So it is entirely possible if they hear this that they, the jury, will be confused into thinking, here's Mr. Copeland saying Shannon and Mr. Garlington are out shooting at a car. And that would not be fair to the defense. So is there a way that maybe we can redact out that little part about they shot at the car, since nobody knows who the theys are if you don't listen to the whole 4 interviews in their entirety to know the context of it, so that we don't confuse the jury? Yes, there is a way to do that, is your answer.
Yeah. Later on in his answer, he's saying, I don't leave the house anymore. I stay away. So I don't think that confusing sentence really adds
anything to it.
Yes, there's a way we can redact this, Your Honor.
So y'all can just redact out that part?
Yes.
All right. So that is 65 line, is that 65? Yeah, 65 line 5, the part that says since they shot at the car. So the rest of it's fine, right? Is the rest of it's fine, Mr. Sharp, essentially?
Yes.
Okay. Next.
The next part we have, Your Honor, is page 155, line 1, through page 156, line 2.
Okay.
Interacted with him daily. When I hear stories about how he was afraid to come to the house and talk about certain things that Chris did, there are many things he shared with me that I'm sure you don't want to hear in terms of his treatment beyond our house. It's in my letter, and I know you've read it. I also know that you have access to DCP&P reports. There's a lot of factual information that didn't come out in the trial, and it's a shame. I know you consider, and the judge, the jury considered only the evidence that was presented. The problem is all this information went out through the media, and only one side went out. You've noticed since day one that my family and I sat back and said nothing. There's much we could say to counter what was being presented here and what was being presented in terms of attacking us on social media. There's so much more to say. I trust that you've read the 8-page report, statements on the telephone, everything that I said, there's not my opinion, it actually happened. The problem is, those 8 pages are not read to anyone else. It's going to be up to me and my family subsequent to this to get that information out. Because what was presented here is so one-sided. I don't know, and I don't want to use the word fair or equitable, but in terms of Corey's upbringing and how well he was doing,
by this time, Mr. Copeland has determined that an individual by the name of Kelvin Watts, as well as some of his friends, I guess, were responsible. And I think Mr. Copeland was allegedly shot out. I think Mr. Williams was allegedly shot at or present in the gambling house. Maybe some other individuals as well. Mr. Copeland tells a story, and it's tough to really grasp from the transcript, but no one knew who did, according to Mr. Copeland, no one knew who did this shooting. It was supposedly, and everyone thought it was another group called NBC who had jumped Demekion Garlington on that same day at a club somewhere. So the thought was NBC was responsible for shooting the gambling house. Now, by this time on the interview, Mr. Copeland has determined it was Kelvin Watts. How did he determine it was Kelvin Watts? What's his basis? Well, Kelvin Watts was apparently dating a lady named Trevia, who Mr. Sledge also dated. So the flow of information, as I understand it, is Kelvin Watts, according to Mr. Copeland, Kelvin Watts tells Trevia that he was responsible for shooting up the gambling house. Then Trevia tells Mr. Sledge, and then Mr. Sledge tells Mr. Copeland. So these are not observations based on Mr. Copeland's firsthand knowledge. These are, it's like game of telephone at this point. And he was under the impression that it was NBC based on speculation. So, you know, if Mr. Copeland gets on the stand and starts talking about what he saw at the gambling house that night, that's one thing. My understanding he was there, but to say he did it and all the rest is just layer and layer of hearsay. And then on top of that, he's talking about Mr. Garlington being jumped at the club by NBC, and my understanding is Mr. Copeland was at the gambling house and not at the club, so I don't know what his basis of knowledge on that is either. So he's talking about two different things that he doesn't know.
Okay.
So I'm not sure what the shark saying. He doesn't know about the shooting. He does know about the shooting because he was present at the shooting. So the shooting.
Right. For that, it's who's responsible for it might be hearsay on hearsay on hearsay. What do you say to that?
Well, what he says here now is that Gucci, he found out from one person, which was Gucci Red, and that is not Antrevia Smith. That's two different people. Gucci Red and Antrevia are two different people.
Okay, so where's the part where he says, here's who I knew it from?
So if you go to page 156, it says unintelligible, so you need to hear it. But it says Gucci Red. I can play that portion for you.
What part of, give me a line number.
Line 17.
Okay.
And if we scroll up to line 15, it says, goddamn, the next night we at the gambling house. They ain't putting no picture. We in there gambling. They taking pictures and shit. Then they came up and shot at us. Only reason we found out it was Kel. He had got into it with Gucci Red. And then she talked to them and she came back and told us, like, man, that was Kel and them that shot y'all. Make it seem like they did because they shot it up.
Okay.
And then they went and shot at another spot. And then Monday we got into it with NBC. And then he goes on to talk about whatever happened between them and NBC. So whether or not Gucci Red told them that Kel shot at them is irrelevant, because what this incident at the gambling house does is kind of form the basis of other events that happened after the gambling house. So some key incidents early on in this conflict between YFN and YSL is there's the gambling house shooting, and that becomes important because after the shooting, I believe it's the next week or the next day at Cascade Skating Ring, Kel, who's the person who shoots at them, and Mr. Williams have a phone call in the presence of Copeland, in which Mr. Williams wants Kel to pay for his car window. So this, whether or not Gucci Red told him doesn't matter. It's what happens afterwards, which is the impetus for this conversation about paying for the car that was shot up at the gambling house.
Okay.
I mean, in other parts in the discovery, it's the flow of information is described as different, but
Surely I didn't watch the Logan. I forgot I muted the mic, man.
Well, it is, but they're saying they're not offering it for the truth. Right?
Yes, Your Honor, it's the effect on the listeners, which everything that happens after it derives from them knowing that it was Kel who shot at them.
All right, so if that's the only objection, then I'm going to overrule that objection. Okay.
Next, Your Honor, is page 173, line 7 through page 174, line 2.
Okay.
Well,
All right, Mr. Sharp, you want to articulate your argument?
And, Ms. Hilton, you said it ended at 174 too?
Yes, sir.
so what?
I'm just trying to get it.
For yourself, so. Smoke. Yeah, they just talking about all that shit out there that's going on.
Right.
Trying to see they can get tossed out most days things. Yeah, I got a bad shit.
Your next is page
Day 104.
181,
Like this five
line
days.
8 through 12.
That's not waiting. Respectfully, buddy, you didn't tell me some shit, man. Nah, hell. Yeah.
All right. Can,
And
any
we
chance we can just get rid of that?
Yeah, we
Okay.
have an objection to that.
There we go.
Which one is somebody? Is this one? Or is that Route 11? One of them shits is Salina.
And the last one we have is
That's
page
11.
185, line 17, through page 186, line 19.
Yeah, Route 11 in South Carolina. You said what? Oh. Yeah, for I ain't no shit, brother. And it's just like a small one.
And you're right, we're okay with redacting.
Entirely? Just trying to get clear what you're saying there.
Yes.
Okay, so that'll be 185, line 17 through 186, line 19 will be out by agreement. Okay?
Where the fuck you gotta go, Lucky?
What's our next portion of this transcript?
That's the conclusion that we have.
Oh, okay, well. Okay, what's our next statement we're moving to?
We can do February 20th.
Okay.
Nah, he ain't on me, dog. Yeah, he ain't on us both, dog. That nigga ain't right, dog.
And is there an associated trial transcript where y'all are arguing this that might be beneficial to look at? I mean, we didn't end up using that other one very much, but.
I should allow this for this stuff part.
I mean, if you're not going to be using it, then that's fine.
Well, I'm trying to remember. I haven't seen the transcript.
Okay.
And February 20 may have been earlier before the break.
Oh, well, hey, then we don't need to rehash that one.
And that's what I'm trying to figure out. For January 11th and February 20th, I'm trying to figure out when we had those arguments because we actually played those videos on the.
Okay.
Right. We haven't received the transcript when we discussed January 11th or February 20th, so I don't have.
Everything be out for me. We get a house.
And those who had the minimal, we agreed on most of that.
Okay. And they've already been played. Y'all just aren't sure whether it was pre or post recusal motion. Is that what you're saying?
Yes, those two videos were played. Let me back up so the record's clear. The video for January 11th and the video for February 20th.
Burning.
At least on the 14th, and I believe on the 17th of June.
Okay, but
I assume that the argument may have happened.
Are you giving her the big one, buddy?
Okay.
I don't know if the argument.
Buddy out there trying to give her the big one, buddy.
I can't recall if it happened pre
This nigga going crazy at work right now, buddy. Yeah.
Okay.
We got some old lady in the back of the truck. Yeah, I'm about to give you the big one, baby. We got you, baby. Hold up, man. Get the wobble with the chopper. See? Everybody out there freaking out there. They're pretty good there.
I just want to make sure. What does this?
You're the moon.
It looks like portions of the January 11th were played before. A very small portion. It's like 30 seconds of it.
Was played before what? Okay. So would that indicate to y'all that y'all had already hashed out the evidentiary issues with regard to the January 11th statement prior to the motion to recuse being filed? It would indicate that to me, but did you at least do the entirety of this January 11th statement at the same time? By which I mean, that was not at all clear. Did you handle the evidentiary issues with the January 11th transcript all at the same time?
I knew what you were asking. I don't know the answer to it, and this is why, because
okay.
And this matches my recollection. This Hilton used January 11th as one very particular point, 30 seconds,
right,
to Mr. Copeland. So I don't know if we had reviewed the whole, and she also played a 10-second clip of the January 28th interview before the motion to recuse.
All right.
And a 12-second clip of the February 20th. But I'm trying to see if there's any note about when we discussed reactions.
So I know that after the jury leaves and hasn't yet come back, y'all discussed the January 21st and the February 21st one. So y'all had not done those pre-interview. I'm not helping, am I? I'm making it more, okay, yep, no, I don't know what that means. February 21st. I don't know. So if y'all don't know whether you dealt with all of January 11th at the same time or not.
So, Your Honor, initially, I impeached Mr. Copeland as the issue or the topic came up. Then when it turned to everything's a lie, then we went to getting in the entire statement. Or playing the entire statement. And so when we had argument.
All right, so you spent a lot of time after the Yes, yes.
I'm looking at notes for 6/17/24. We sent redactions regarding. We were discussing redactions, I think, on the 17th regarding January 11th, January 28th, February 20th, February 21 interviews. That leads me to believe that these were not redacted prior to the 12th.
Okay. Well, y'all said y'all are close on those anyway, so why don't we just.
So I think
if it's me revisiting and ruling differently, then maybe lucky state, maybe lucky defense. Who knows? I don't know.
So I think the next video we can actually go to is January 28th because that is where we had some more redactions.
So are y'all just then, as to January 11th and February 20th, y'all said, I think, that there isn't much y'all disagreed with about that anyway?
That's my recollection.
All right, so maybe y'all can get to huddle up together on those two, and maybe y'all can come to agreement. If not, you can either figure out was the ruling made before the motion to recuse, or if there are two or three things and we don't know when the ruling was made, just bring them to me.
Yes, Your Honor.
Okay. Okay, so then we'll move on to February 28th. Is that what you said?
January 28th.
January 28th. Right, February 21st, January 28th. I am just making it that much more confusing. Sorry, y'all. Mr. Harvey's going to use that later when I say that. Even the judge admitted it. I'm teasing you, Mr. Harvey, although I bet you will. Okay, January 28th.
Yes. So
and that has either not been discussed or it was discussed post-recusal motion.
Discussed post-recusal.
Okay, and so do we need to look at a transcript, or Mr. Shart, you're just gonna?
If the state has a transcript of this motion, this interview.
February, January 28th. All right, we can, I assume we have the one that, ours came, I don't know where ours came from, if they came from Ms. Weaver or from the state, but Ms. Firstfield will forward you what we have. Is everybody good? Does anybody need a break? Quick break, 10-minute break. Let's come back at 3.
circumstances under which he acted. In light of all the evidence, the jury had to find beyond a reasonable doubt that the defendant's conduct resulted in a probability of death as opposed to a mere possibility of death. And if so, the jury could then find, as it did, that the defendant acted under circumstances manifesting extreme indifference to the value of human life. So, therefore, on the aggravated manslaughter charge, I can't say I'm going to double count and it was extremely heinous and cruel, because extremely heinous and cruel is an example of conduct manifesting extreme indifference to human life. And one of the reasons it's extremely indifferent is because it was perpetrated on a 6-year-old, 60-pound boy who obviously wasn't capable of resistance. So for those reasons, I respectfully disagree with the argument that I could find those factors. I can find aggravating factor 3, that the defendant is likely to commit a new offense. Based upon the defendant's disorderly persons offense record, based upon the defendant's attempt to influence his mother's testimony, which caused defense counsel to then forego calling his mother as a witness. His mother had testified at pretrial hearings before this court outside the presence of the jury. After one of those hearings, defendant speaking to his mother on a recorded line from the Ocean County Jail,
I'm watching this sentence and this nigga
engaged in attempts which the state portrayed as attempting to influence or tamper with her testimony. The parties came in the next day outside the presence of the jury, or the next court day, and brought that to my attention, submitted a transcript to me, and the parties also indicated that the actual recording is worse than a reading of the cold transcript. I'm permitted to consider that because that was evidence on this record and shows someone who, even in the course of the trial, with extremely effective and experienced criminal defense counsel, was still trying to undermine the criminal justice process. I'm also permitted to consider defendant's attempts to flee jurisdiction after Corey's death on April 2nd, 2021. He did not simply leave the hospital and drive to, say, a relative's house or to some other location close by. Defendant drove all the way to Arkansas. I don't know, and I didn't allow an answer to the question of whether or not he was on the way to Mexico, because that would have been speculation, but he was, by Detective Sergeant Raymond Cole's testimony, 45 minutes from the Texas border. Never once in this case has anyone submitted there were any relatives in Texas or in Arkansas, but the behavior was, in an understatement, peculiar at least. This was not a defendant that left and went a few miles away. It's true the defendant did turn around at some point. His father testified at his father's urging to come back, likely because it made him look guilty, and it certainly did make him look guilty. I'm also entitled to consider, as aggravating factor 3, that the defendant committed these two separate acts on separate dates, that the treadmill video shows a callous display of the defendant towards Corey. In addition, despite a long prison sentence, the defendant can still commit new crimes while incarcerated. Someone who's violent, who lacks impulse control, who's motivated by anger, can reoffend while in a correctional setting against corrections officers, civilian corrections staff, medical staff, or other inmates, particularly if another person is vulnerable, incapable of resistance. But it's worth describing some other aspects of the treadmill video. We will, of course, focus on Corey's repeated falls on the video, what can be really described as the child being ejected off the video, almost like on a conveyor belt. And I remember the reaction from the jurors when they first saw it. They sucked in their breath when they saw that. And then you see Corey getting back on and it happening again and again. In fact, even before the first fall, you see this young man get on a treadmill and run like he's a champion. I can't imagine a 6-year-old who was able to do that. I was so surprised by that. He obviously knows how to use that treadmill. And then he's doing a great job for several minutes while his father is working out in the gym, doing various exercises. And then his father comes over and starts to increase the speed and perhaps the incline. And Corey tries to keep up. And you keep, when you're looking, you keep hoping that, okay, it's only going to be for a short sprint. But it just keeps going. And you see on the tread, Corey falling further and further behind. The defender doesn't walk around behind him to grab him. And you see finally he can't keep up. And then to everyone's horror, you see what happens as it goes on 5 more times. Mr. Gallucci
That
described that
nigga
to the jury
ignored
in his opening
everybody,
statement
brother.
as
He technically
horrifying.
wasn't
Told
on
the
the
jury they
phone
were
with
going
us.
to
I don't
find it
think they were
horrifying, and that was
arguing.
obviously strategic to
know
try
that
and
one?
minimize the impact of it. But because it is so horrifying, what do we kind of discount in the rest of that video? It's actually 4 separate videos, but the totality of the circumstances from when Corey arrives at the apartment complex and goes into the gym with his father till he leaves. You see Corey being brought into the parking lot by his mother and getting out of the car.
What
You
you
see
mean?
the defendant approach the car. There is no loving interaction between Mr. Greger and Corey. There's none of the
Respectfully, you just trying to give me a
kindness
song on
you would
something.
expect to see from a father who claims
They
to
would
have
have
left
had it.
Baltimore,
They would have got my
give up
money
his
because I would have
career
had to shut
to come
Valley
home
down,
to New
buddy.
Jersey and be a father. There's no little pat on the back, no hug, no high five to Corey. Corey goes right in, and the state alleges that defendant puts up 2 fingers to say you're 2 hours late, and that's your punishment. I don't know if that's accurate or not, but he does. There is a shot of him holding up 2 fingers. And then after Corey falls repeatedly, and then they walk out,
That part.
there's no loving interaction. There's no pat on the back. Good job, son.
Buddy, he wanna
There's
smack
no
people,
hug.
buddy.
Are you okay, son? There's nothing.
He wanna
In
smack
fact,
people,
the
buddy.
defendant walks out, and Corey is trailing behind him, having to grab the door himself.
Put that nigga in
I'm not
karate.
denigrating Corey when I say that, but he's being treated by the defendant like he's the stray dog following along. So, while I respect the character letters I've received saying what a loving father he is, a picture is worth 1,000 words, and a
Put him
video is
in
worth
karate,
10,000
buddy.
words. So whatever happened that day,
Put him in karate, buddy.
Corey was not receiving love or companionship or kindness or support. He
I want
wasn't
him-
even receiving what could be
I want him
described
to
as
kick people in the face,
a
guys.
tough father was going to raise him to be a man. Get back on the bike when you fell off. That was abuse of the most egregious sort. And it doesn't
Yeah, I'll do
square with
boxing.
the defendant's statements
Nah, I
today.
ain't doing boxing because I don't want him to hit my son back. I just want him to knock people out, guys.
Now, to say that, however, I'm not suggesting that
Never.
Corey was mistreated at his
I
grandparents'
want him
home
to be
in
the same
Monroe.
way that I am, buddy.
There's
If
nothing
someone
to
actually
indicate to
bothers
me
me, guys.
that what happened at his grandparents' home was anything other than appropriate. His
When the time is
mother and
right,
father testified,
I'll show you the
both,
inner force.
the mother
of them all.
outside the presence of the jury, the father inside the presence of the jury.
I've never been a bully.
Although I don't want to get into all the social media attention, I would say that both sides, Corey's mom's side and defendant's parents, have a right to closure in this matter. And this venom back and forth should not be directed by either side. The individual responsible for Corey's death and for Corey's endangerment stands before the court today in a green and white jumpsuit, and the focus should be on him. Based upon all that, I find aggravating factor 3 is present, and I give it moderate weight. I say moderate
Everybody,
weight
you gotta-
because of the lack of a serious record.
You, nigga, you gotta use your
Let's
legs,
talk
guys.
about that record for a minute. The pre-sentence report
Use your
confirms
legs,
that
blood.
This marijuana offense, again, it's not an
Blood.
egregious
Use your legs,
offense.
blood.
In fact, the under 50 grams is no longer a crime or offense in New Jersey. The drug paraphernalia, which the defendant pled guilty to, is a disorderly person's offense still in New Jersey, so I'm allowed to consider it. It has a February 2020 data
Respect.
violation, and just a week or so later. Whatever happened that day, Corey was not mom's side, and defendant's parents have a right to closure in this matter, and this venom back and forth should not be directed by either side. The individual responsible for Corey's death and for Corey's endangerment stands before the court today in a green and white jumpsuit, and the focus should be on him. Based upon all that, I find aggravating factor 3 is present, and I give it moderate weight. I say moderate weight because of the lack of a serious
I think this shit about to be over, y'all.
Just 3 minutes. I think we might be able to get through this much quicker.
serious record. But let's talk about that record for a minute. The pre-sentence report confirms that this marijuana offense, again, it's not an egregious offense. In fact, the under 50 grams is no longer a crime or offense in New Jersey. The drug paraphernalia, which the defendant pled guilty to, is a disorderly person's offense still in New Jersey, so I'm allowed to consider it. It has a February 2020 date of violation, and just a week or so later, the imposition of a fine. But why is that date so significant in 2020? Because this is the man that returned from Baltimore in 2019 to come back and take care of his child, to give up his career, to be a great dad. We didn't have to do that. He could have said, listen, I've relocated, I didn't know I had Corey, I'll pay child support. But he's portrayed by himself and his family as being this unselfish, altruistic person that gave up a career with urban teachers, that left a position where he obtained what appears to be an extraordinary education, a master's degree in special education with a secondary degree in mathematics at what is by all accounts a nationally, if not world-renowned university. But he came back here and he gets arrested for drug use at a time when he's going through custody battles. So I'm going to come back, I'm going to come here, I'm going to try and be the best father I can. I'm going back and forth to family court. There's all these orders back and forth. The mother, who admitted it, that she struggled with substance abuse, but yet I'm going to place myself in such a reckless situation that I get arrested, to the point where the defendant was ordered by the Division of Child Protection and Permanency to attend a treatment program through Catholic Charities in order to be approved for parenting. So that adds to my finding as to aggravating factor 3, that the defendant, even under those circumstances, was motivated to
allegedly a member of IF, or an affiliated subset of IF, and he's a rapper. And I think the state's theory in some
You talking about? I've heard of a person in general being allergic to grass, yes. I don't think I've ever seen a white person like that. No, I don't know that.
contemplates
What do you mean?
at least the threat of serious harm. In fact, it's almost difficult to accept the medical testimony that the treadmill did not cause serious injuries. Dr. Andrew, I believe even Dr. Bodden, testified there were some abrasions, some bruising, but Corey did not sustain serious harm from that. But any reasonable, objective person watching that video would certainly say it threatened serious harm, particularly for such a small child. It would threaten serious harm for an adult to be on a treadmill.
I think the state's theory in some ways is that it was considering between Buddy J.
I don't eat grits neither.
Mr. Williams, because
Nah, I don't fuck with it.
about Mr. Williams, Mr. Jeffrey Williams, I should say, and Mr. Copeland.
Yeah, buddy. I don't eat what they consider slave food, buddy.
They say that Birdman,
I don't eat none of that slave food, buddy.
Birdman wanted to sign Buddy J, but Jeffrey Williams they had between each other, and he was blocking Birdman from signing Bloody J. But so that's the background of this. But the bottom line is, Mr. Copeland saying they said that Birdman wanted to sign Bloody J. There's absolutely no indication. My understanding is that Mr. Brian Williams is a multi-millionaire who runs a big record label. There's absolutely no indication that Brian Williams is running his ideas of who's going to sign, not to Ken Copeland. And Ken Copeland's just kind of, and he says it. He says they say this, they say that. And so that's all hearsay from our perspective. It's all speculation. It's not based on understanding. And Brian Williams is on the state's witness list. So if they want to call Brian Williams and ask him about what his plans were to sign Bloody J, but Mr. Jeffrey Williams didn't allegedly stop him, they could certainly ask Brian Williams.
And Your Honor, the state has no objection to page 43, starting at line 4 through page 44, line 8. The only portion that the state wants in is page 42, line 3 to page 43, line 2. Mr. Copeland, is either in this interview or one of the other interviews, talks about how he actually brought back, or he tried to get Bloody J and Mr. Williams to kind of, at some point, start working together again. So he has some familiarity, we believe, with the relationship between Mr. Williams and Mr. Ussery. So when he's on page 42, when Investigator Dennis asked, so what happened with Bloody J? Weren't they cool? He explains his understanding of when they may have started to fall out. This transcript is not the best, but some of what I believe is in this transcript, if you go to line 12, when you said you was trying to hook them back up, what happened? Like, did they fall out? Was it a beef or something? His response, I think they did because Bloody J joined they gang. Whose gang? If gang is what it actually says.
That's not saying game.
No, it says,
it's gang, G-A-N-G.
and it's saying if gang, I-F gang. He says, and I guess he was down with YSL, and I'm at line 23, and then it says, you know what I'm saying? So he joined them. And so that's his understanding of where their beef started at some point between Bloody J and Mr. Williams. And this is corroborated, Your Honor, because we have video evidence that at least back in 2012, Mr. Williams and Mr. Ussery, they're releasing music videos together. At the time, it looks like it's a ABG or Atlanta Blood Gang music video, but they are friends. And we know that the friendship dissolved sometime after 2012, which will corroborate or lean into what Mr. Copeland knows about their relationship. So we that's the only portion we wanted in, which was page 42, line 2, up to page 43, line 1.
And so I understand the objection to that being this, for all we know, is hearsay about why they fell out.
I think it's the way that he speaks, and if you watch it, it doesn't seem like he's saying they, like this is something they told him, because he says, when you said you was trying to hook them back up, what happened? Because he was trying to bring them back together. So it seems the state understands that he has personal knowledge of how the relationship dissolved, not something that he overheard or, but something that he's.
Why don't we just maybe find that out?
Yes.
Additionally, if Mr. Copeland, outside the jury's presence, and if he has personal knowledge of it, then that's.
The next portion that is in disputes, Your Honor, is page 203. Excuse me. I need to find out from Mr. Shard if he looked at what we discussed of 80804 all the way through 81150.
Can I back up on one? My notes may be wrong. Did you agree to number 5? 750 to 750?
Yes, we're not going to contest that.
All right, so where are we now?
80804
And
to
those are
8.
the timestamps.
So roughly page 178.
This is a big one. We agree from 80804 to 809.
Right, and I don't have the
So
timestamps, so.
page 178, line 7 to page 180, line 8.
And the state wants to go beyond that. And what happens after 180, line 8 is very interesting. Okay. This is January 28, 2015 that this girl was speaking. He spoke on January 11, 2015, speaks on January 28, 2015. February 20th and 21st, 2015. And then on June 10th, 2015 is the first time he says that my client and other individuals are responsible for Donovan Thomas's murder. In this segment right here that the state's wishing to redact, they ask him about who he thinks or who's responsible for Donovan Thomas's murder. And he says, well, what my understanding is, or what I've heard, now mind you, his stance on June 10th is he knew that my client and others committed this murder that night. So he was in knowledge of it that night. Right. On January 28, 2015, they're asking him, who's responsible for Donovan Thomas's murder? And he says, well, I believe, or I heard, and I'm not asking him to admit it for the truth of the matter asserted. I'm asking to show that his story's changed and he didn't say it initially. He said, well, I heard that Kelvin Watts had robbed someone and then Donovan Thomas was murdered as a result of that. And I believe, I'm not going directly off the transcript, but he puts forth different theories on what happened to Donovan Thomas. And our stance is that's important for the defense because if he was a truthful person who was telling the truth, he would have said that then. Now, the other interesting thing is on all these other dates that he's given these statements, he's not facing arrest. Mm-hmm. It's not until he's facing arrest that he points his finger at my client and others. So to us, that's a very important fact. And it's not being offered for the truth of the matter asserted. It's being offered to show that what Mr. Copeland has said at different times, when common sense would dictate if he's being a truthful person, he would have said what the state's saying the truth is.
All right, are you sure this is 178, line 7 through 180, line 8? Because I don't see this being about any of.
So that's the part we agreed on. And then they want to go beyond that. Okay. And starting at 180, about 180, line 8.
Okay.
And we want to keep it in.
Good. So 180, line 8 through what the state wants out.
Until 186, line 2.
And why, I mean, maybe get the gist of it, why does the state think
Because it's a lot of rumors. This is actually not him testifying from personal knowledge. When he first starts on page 180.
I would concede it's not personal. I would concede that's not personal knowledge.
So think that they can cross-examine him on whether or not, why didn't he tell the police early on, but all of his speculation about what the rumors are, that's putting in information in front of the jury that's based on speculation and rumors. If they want to cross him and say, on January 28th, you didn't disclose that any of these people did it, I think that's fair for cross-examination, but to actually introduce this statement of him speculating as to what may or may not have happened on the night of the murder, it's just that, it's rumors and speculation.
There's a fundamental difference between not coming forward with information and being asked about something and coming forward with other information.
maybe I need to listen to it, because I don't really see in this transcript at least, except for on page, the very end of 184 and beginning of 185, maybe? And I'm not even sure if that seems to be the only thing they're talking about, that getting killed.
The beginning part of what they want out, and so there's after the part with our agreement, they talk a little bit about an incident where Kelvin Watts shows up at Lucci's mother's house after it's been shot up with a gun.
Yeah.
That is a separate, so I don't want the court to be confused. That is not the nut.
Right.
The Donovan Thomas murder.
Okay, so do you want that part here?
I do want it in. If you ask me why it should be in, I want it in. But the reality is, I don't believe that Mr. Came to the court. I don't believe that Mr. Copeland has firsthand knowledge of that, and that doesn't really fall under my argument about the Donovan Thomas.
All right, then you agree that we don't have to talk about that part. So point me to the part where we actually, that you, the defense for Mr. Stillwell, want in and think appropriately can come in under the
Respectfully, I think we need to just play it, because
That's
I can't,
fine.
the transcript is so long.
Okay, yeah, no, I mean, I think so too. But certainly, it's not that part about Lucci and Lucci's mom. All right, so can somebody?
Yes, so I'm going to start around, as a review, at 8:08:30, which should reasonably be somewhere on page 179, probably around line 7.
When she was, she can come out, and then like Rich on the corner door had a show. And I was there, and Rich on the corner came, but Rich on the corner tried to play both sides. So
he like the kind of like.
Yeah, so he just like, bro, man, I'm tell you how serious it is, bro. Kill try to kill anybody, bro. He told me to call Max and tell her, trick her down here so he can kill her. Just to get back into it. Yeah, he said like he want to kill somebody that way gonna hurt. What the hell? Do what he's saying. Rich on the corner, you bond him out of jail. Lucci ain't gonna pay his bond. They said he mad at Lucci because Lucci ain't pay his bond.
Why? Why Lucci ain't pay his bond?
But what don't make sense, let's say, okay, what word did we get, right? Somebody said that Kel was called over there to the house after he got shot up. So at Lucci Mama's house? Yes. All we heard was Lucci Mama's house got shot up. Kel pulled up with the guns. Then we come to the tree. Kel pulled up with the guns in the car. And police walked up, searched the car, found the gun, locked him up. But why
was he there? Who brought him there?
I don't know.
Lucci Mama's house. Kel, come. Who brought him to Lucci Mama's house? Like, how did he know he got shot up?
Like, do we just hang out in the driveway? I don't know. They probably, you know.
So if that's the case, and then he got locked up, why did Lucci want to pay his bond? You know what I'm saying? And I basically
called you and said, yo, my house got shot, my town.
Check on.
And then the red Camaro Lucci got, the same car they ran around, they shot my girl mama's house up. That's Lucci car. You know what I'm saying? But I ain't get it. You know what I'm saying? They got my name on so much stuff. Like, people that come and tell us, they tell us a little bit, then they start talking about it's me. You know what I'm saying? Like, my girl, she get a lot of information from her friends. She got a lot of friends, so they get around me. Lucci and them was talking in the studio, and it was a girl in there. They missed one of them, and she my girlfriend. And she said that ain't nobody can do that. Nothing. You know what I'm saying? They was all like Kel and K robbed somebody. You know what I'm saying?
Kel and who?
K.
Who's K?
I sent you a picture of that too then. I think I sent to those details. They had Chop on in the picture. Oh, yeah. And the them was in the car. Yeah, them two robbed somebody, and they supposed to came back. This is they talk about in the studio. You know what I'm saying? They just put my name on it. They covered it up. Niggas seem like they ain't got beef in the streets, whatever. Yeah. And then it's like, she be like, they know we can't do it. You know what I'm saying? But they gonna keep playing on him. And she be like, K, when the nigga got killed, K first one called everybody like, we killed Nut. We killed Nut. Tell the mom now we did. He the first one started my name. And they like, Kel went along with it. So they said, Jerry Ross, then they did. Like, Nut died, then they started. That same day? I don't know when. They like, they just Ross, man. And niggas supposed to be coming back for them. You know what I'm saying? Like, Kel robbed Flat. Flat. He robbed one of them. Like, and then, like, they would have somebody broke in that car. And gave me the phone. And the jury.
Stop looking at 8/11/50. So, Your Honor, and look at a lot of it is these just rumors about what he's hearing about what happened leading up to the murder.
I don't even know if they're rumors that he heard. He might be completely making it up and never even heard a rumor, but that's besides the point. They're asking what happened, how did Nut get killed, and he proffers a theory or a story that that Kel and Kay robbed someone, and then those people came back and killed Nut. And that is, and the relevance of that is it's not for the truth of the matter asserted. I don't think anyone in this courtroom, at least on this side of the
I'll be right back, Chap.
is going to get up in closing and argue that the real killers of Donovan Thomas were, I'm hearing the name Nick, and maybe I'm following the story correctly or not, that Nick, after being robbed by Kel and Kay, came back for revenge and killed Donovan Thomas. We're not arguing that that's true. What we're saying is simply that, according to the state's theory, Mr. Copeland had inside information on January 10th, 2015, and about our clients committing a crime, and then he's asked about it on January 28th, and not only does he not, it's one thing not to mention our clients, which is important, but it's a whole nother thing to put a different theory out there. And so we think that's very relevant, and that goes to his credibility. And I understand he's arguing to everyone that he has no credibility, but the state is arguing that there is credibility with his June 10th, 2015 statement, and we're saying there's no credibility to that either.
No, that's not saying, Your Honor. I don't think the two are not mutually exclusive. He can know the truth, but proper rumors, but what those rumors are is they're not competent evidence. Like what he's saying, they can cross him without this coming in about the fact that he told the rumors. You told the police rumors in January. What those rumors are is not competent evidence because it's all speculation. It's all rumors. But they can clearly ask him that on the stand without going into.
All right, and I assume that the only reason June 10th comes in anyway is because he takes the stand and says, I don't know anything about anything. I don't remember. Right. And so June 10th comes in as a prior inconsistent statement.
Yes, Your Honor. Because prior to everything, his response is everything in June 10th, again, the whole finessing, and then he's now changing the version of facts as to what happened back in January 2015. He's now changed some of those facts. I don't know what he will do when he comes back, but that's what he can do.
So the defense, if the state can stand up and go, all right, here's your prior inconsistent statement where you said X, Y, and Z, which was all these people over here on this side of the room killed by, then they want to be able to say, well, look, in January you said something different. Explain that. Why shouldn't they get to do that?
I think they can ask him about, in January you said it was all rumors. You said that. You said that there were rumors. What those rumors are, I don't think it's relevant. They can definitely ask him. Now, whether or not he says, I never gave anyone a rumor, then maybe that might open the door for something else. But for the state to play it initially, if we even get to play the statement, all these rumors coming in, I think there will have to be some foundation about the substance of the rumors if they come in. But they can ask him simply on the stand, you told rumors, and if he says yes, then that's it. What the rumors are will be irrelevant.
We've all been doing this long enough to know that one of the things that makes stories ring true sometimes is the inclusion of detail. It'd be one thing if he just said, John, I heard John killed Donovan Thomas. But he didn't do that. In this story he gave, he gives details. He gives a story, a coherent story. And that matters. It's not just that he gave rumors, he gave a coherent, detailed theory. And the state, I'm sure at some point, is going to argue to this jury that, oh, well, he was telling the truth on June 10th because look at the details he gave. How would he ever come up with this story that it was these specific 4 gentlemen in the car? How would he ever? And we're seeing on January 28th, he is giving a detailed story with individuals and a motive and all the rest. And so I don't think that it does. I think something is lost if we were limited to just say, oh, well, you talked about rumors on January 28th. That really doesn't do it justice. We should be able to get into exactly what he said. And again, we're not going to argue that that's the truth. We're just going to argue that it's Mr. Copeland's ability to think on the fly and come up with detailed stories. And when he was given an opportunity to explain what happened, he came with a detailed story that had nothing to do with our clients. We think that's fair game.
Well, I mean, you can certainly ask him about it. You can ask him in as much detail as possible as you want to. And I think it's going to depend what he says then.
Okay.
Oh, me? Yes, sorry.
So maybe if you're saying, I'm not presuming that he's going to deny saying this. So yes, if we ask him on the stand and on cross-examination, leading questions, and he confirms that on January 28th he told about
this
all that
story
stuff,
about,
then
right.
I can see that we wouldn't
That's it.
necessarily get
Yeah.
to play.
Okay.
But I think, as I understand it, the state's saying that we don't even get to go there.
Oh, no, they're not saying that. You agree they can cross him as much as they want to on, hey, this was your theory or rumor or whatever that you told the police on January 28th. They can ask him about that, right? I mean, you agree to that.
Are you asking if he can say, this is what I told the police?
Can they say, do you have a dispute with them being able to cross Mr. Copeland and say, well, on January 28th, when you were talking to the police, you told them that you heard from the street that Kay and whomever robbed so-and-so, and it was those people that then killed Nutt?
So the state's concern is, even in the interview, he doesn't say it as fact. He doesn't say, this is what happened.
Well, sure.
He said, this is what I heard.
Yeah.
So to me, it's still speculative as to what he heard on the street. Whatever the rumor was, to me, is still speculation. I think an inquiry could be, you didn't tell them on January 28th that Shannon, Stillwell, these people did. You only proffered rumors, not the...
But they can, so you think they can ask, you told rumors, but they can't ask, what is the rumor you told them?
Correct.
That is not correct. You can, in fact, ask them about the detail of the rumor that he told them. As long as, I mean, obviously he is clearly saying this is a rumor I heard on the street. And I know your point's going to be, well, that's an awfully detailed rumor. And you could argue that later. But yes, you can get into the detail of, didn't you tell them you heard X and Y and Z? And then if he says, yeah, I lied about that too, then that's the end of it. If he says, no, man, I never said a thing like that in my life, then we may be able to actually play that part.
That's fine. We still believe that the rumor is speculation, but we
No,
understand.
it is. I mean, he says it is. He says, this is what my girlfriend told me she heard from somebody else. It's clearly a rumor. That is not their point. Their point is you, at some earlier point, are telling the police some theory, albeit rumor, albeit street talk, that is some details. And I think they're going to argue whatever they're going to argue, but they can get into the substance of what that rumor is. They can't mislead that this is what you said as fact. It has to be still, this was the rumor you told them, but they can get into the detail. Mr. Steele.
Well, I think what you just said is what I wanted to ensure that we
Yes.
do. So
Okay.
I think we're good. And Your Honor,
He's just saying I'm standing up because I wanted to make sure that you already just explained what I was going to ask about.
the one position is, you know, you may know this, but Mr. Copeland didn't say, like, I never said anything. What he actually said was,
I said all of I don't remember exactly what I said, but everything I said was a lie, right?
exactly.
Yeah.
Because the police were making me the number one target. They told me I'm the subject of this
Yeah.
murder, and I wanted to push everything I could away from me and onto others.
Mm-hmm.
So that's why it's very important to show that he's just coming up with, you know, Mr. Lamar's Rich Homie Kwan. He put a hit on another person to kill them. Ask Mr. Copeland. He has 17 people that he says put hits on other people.
Okay.
That's outside of people here.
Okay.
But what you said is exactly right. It doesn't matter. I'm not using it for truth. I'm using it for exactly what he's saying. That's what I was doing.
Okay.
And at trial, he said, and that's what I did for the people here on trial.
Okay.
Thank you.
All right. What's our next portion of this transcript at issue
The next,
or statement?
yes, the next part that's at issue potentially is page 203 line 11 through page 206, line 17.
Okay.
And more specifically, page 206, line 15. To line 17. And Mr. Shaw, are you okay with 82131 through 82137?
So that's 206, 15, and 17. So
yeah, that's going to be page 203, line 1 through 16.
Your Honor, could I just inconvenience the court, ask that 15 seconds or whatever that is potentially in dispute be played? Because I don't think I have an objection, but
Okay.
I can't really tell from this.
Okay.
If I can just hear it.
Sure.
And Your Honor, I'll play with 82131 to the whole section.
Okay.
Me and G together no matter what, just like DB. We was together. You know what I'm saying? We not doing that.
Who killed DB?
They don't even, man. They don't
Who
even.
you think?
I don't know. Trey.
Who DB?
They don't even, man. They don't
Who you
even.
think?
I think you started right after the
portion.
Yeah.
Man, besides Shannon and G, you ain't gonna see me hang with nobody.
So is it a person that you?
No, that's what I said. How the hell I be leaving all the time? Everybody after me. Like, it's not one man. It's not one time.
I'm fine. The state wanted to play that, and I don't have any problem.
Okay.
So right after that, we're in agreement from, I believe, 82137 to 82250.
TD Complete Checking is here for all life's adventures. A job you love, a partner you love, a life you love.
You are the future. Pursue tech careers with the DeVry Scholars Program. Advance your ambition.
Okay.
It's going to start a little early at 822:02.
Okay.
He just showed up. He did kill me. He's tough. I know, but just like you said, somebody, it ain't like I'm putting on the team. That's about what we can prove. Like, just like this little nigga, Lil Hayden. When he just got out of jail, he see me in the club. He walked right up on me. I'm murdering me. Yeah. Who? Little nigga, Lil Hayden. You know, who's supposed to have something to do with GB. Oh, okay. But this nigga walked up on me, nigga, who the hell is you? Yeah. I ain't know him. Yeah. What's up? Best friend, what's up? Why you looking at me like that? Yeah. And me, Bob Simpson, like, I know that's my little brother, Lil Hayden, he just got out. So I'm like he booked, like, shit up. Nigga, what's up?
Hey, look, hey, the one that got shot in the face?
Yeah.
On Boulevard, right?
Yeah.
He out too?
They him. Like, so some corner got a video on his page. How they walking in the house. Saying that he shot my grandmama's house. I know them, all the niggas they did. You know what I'm saying? They pulled up at the house in 3 cars.
So you mean, after this, so is Rich Homie and Thug beefing?
No. How is that not possible though? That's what I try to say. I feel like
he playing both sides.
Nah, I feel like everybody like I feel like fold when he needs. Nah, I feel like they came together and made an agreement to kill me and everything go away. I feel like it, but I'm not gonna run.
Even when
We're past it, and I heard that portion we can keep out.
All right, so what is the portion that is at issue?
No, nothing now. Now that
All righty, I'm glad we all did that.
82259 is where we're gonna go back live on the state. If it's played.
so the full redaction will be 82137 through 82259. Sorry, repeat that. Sorry, the full redaction will be 82137 through 82259. And that's going to be page 203, line 19 through page 206, line 17.
Okay.
We have a series of agreements, Your Honor, and I think there's only one more that we disagree. Is that correct? And it's all the departments.
Okay. Where's that one?
Page 269, line 19 through page 270, line 14.
All right, and is this the part that the state wants in, defense wants out, or the other way around?
Right, if I can do one more time, this might not be.
We both agree that a certain part of this comes out. There's a portion of it where Mr. Copeland somehow talks about a rumor that Donovan Thomas in his dying breath said that Doug was responsible.
Okay.
A, that's not true, but B, that's hearsay. People that were next to Donovan Thomas said that's not true. So, but it's hearsay nonetheless. But I believe that the state wants to not take out a certain segment of this, and that was our disagreement.
We are fine taking out that part.
That part being.
Sorry, what Mr. Shard decision that Thug did.
Okay.
That part we will keep out. We didn't know if the defense has other objections to, and I'm sorry, Your Honor, we're on page 270, line 7. It actually says, he said Thug ass has something to do with it. It's unintelligible, but that is the line that we're referencing.
Okay, so y'all are by agreement taking that out.
So, but I guess at the bottom of 269, we have it written down as 269, 19, 270, 14. Is that correct?
That's what I wrote down, but what y'all might have an objection to, I don't know.
Well,
So, (269:19 through 23), where he's saying some detail about what he heard about Nut getting shot. Is there any dispute about whether that is in or out? I mean, I don't know, y'all.
I agree that is out. My understanding was the state viewed that those timestamps were too large and that something within that time period can get in, but
Okay.
maybe not.
All right, Ms. Hilton, was that something y'all intend to put in?
Initially, yes, but Your Honor,
How about now?
we will not put it
All right, so then 269, line 19, all the way through 270, line 9 is, I'm sorry, 9 or 14 is out by agreement? Which one was it? The end, 9 or 14? No. Okay.
in. So, page 270, line 9.
Line 9. Okay. Yeah. She is out by agreement. All right. So was that the last thing?
Yes.
Okay.
And Your Honor, our agreements for redactions, I guess they'll just, when we email them, they'll be made part of the record that way.
When you email them to whom? What I'd like y'all to do, I mean, for this, we actually, anything we didn't discuss that y'all have an agreement as to, like all of Mr. Adams' stuff, just make a little list and say, the state and the defense agree that XYZ is out. Okay?
Here, I already compiled it from the first time.
Super. Just get together with your colleagues on the other side and make sure they agree and get it filed. Okay, so that's that statement. That's the January 28th statement is taken care of. And y'all are gonna, on January 11th and February 20th, figure out the couple of little things that might be in dispute and then bring those to me. And I doubt if y'all got a chance to do that already. So it seems like then the next statement is June 10th, right?
You wouldn't do that. That's what we did this morning.
That was,
We started with June 10.
We'll go in reverse.
We went in reverse.
all right, okay, you're right. So if we've done
all the 3 that we can do.
And, okay, and then the other 2, y'all are just gonna figure out what the small little differences are. Okay, so then I think the next thing we have to sort out is with regard to the testimony of Mr. Copeland that occurred post-recusal motion. I don't know how many days of transcript of that y'all have yet. I think you have at least 2 or 3 days worth of that, but maybe not all of it from Ms. Weaver, Judge Glanville's court reporter. Some directly from her, some through Ms. Firstfield. Because, right? Have y'all discussed that at all yet?
So Mr. Shard and I discussed briefly that the defense needed to talk amongst themselves.
Okay.
And then they were going to come.
All right. Okay. So over the weekend, y'all figure out both amongst yourselves and then between the defense and the state, if there is anything, and if there is, what, of Mr. Copeland's post-recusal motion testimony, there might be some agreement to. And then also, if y'all can think and propose to me on Monday, whatever y'all think might be appropriate in terms of explaining to the jury if they're going to have to sort of rehear any part of Mr. Copeland's testimony, you know, just what we're going to tell them about that. Okay. And then after Mr. Copeland testifies, What's next? And how long do y'all anticipate that taking? Y'all have no idea, do you? Because who knows what he's going to do.
That part is true. Does the court mean like which witnesses?
Yeah.
Okay, so I anticipate there will be two other potentially Mr. Sledge, Mr. Zachary.
Okay.
Those two.
This is what you gave me. That's basically an order, right?
Yes.
Okay.
Yes.
So then, Mr. Sledge and Mr. Zachary, are there anything about their evidence that we need to hash out? And I can't remember, what did I give you as your deadline to give us all the details about the evidence?
You said the exhibits was Wednesday, but then the witnesses was Monday, and
I thought the first 30 was Monday.
the first 30 yeah.
Okay.
Monday.
All right. Okay. So I honestly did not think we would. I am really glad that we did. Congratulations to everybody. Get through as much as we got through today. But given the last couple of days, I'm pleasantly surprised that we did. So I actually, at this point, told the jury, don't come before Wednesday, because I figured we had enough work to do Monday and Tuesday. And I think that probably is true. But yeah, with everything that you're, and if y'all get finished early, you don't have to wait till Monday morning. You can go ahead and email whatever you get finished with as you're finishing it. All right. So yeah, we can start working on all of that. All right. So this is a good time to adjourn for the day, or do we have other things we want or need to take up right now?
There may be one more thing that we can take up if the court would allow us one more.
Your Honor, we do have the 5 jail calls that we intend to get in through
perfect.
Mr. Copeland.
Yeah, we can do that. Okay. And I've already listened to the portions of.
And there were portions that we did not object to, Your Honor, so I can go through. By call, which one we didn't object to.
So you're working off of, so I know that Mr. Shart had provided kind of June 19th-ish, his proposed redactions, right? Is that what you're working from to tell me which ones you agree to?
Yes. Is that what Mr. Steele sent? No. For the jail calls, I'm looking at Wednesday, June 26th. There was an email that Mr. Steele sent.
I don't know that I have that.
Okay.
What I've got is it may be the same list. Oh, it may be. I don't know. What I have is whatever Judge Glanville had made a court's exhibit when y'all were talking about them. And it says forward Stillwell proposed redactions. Anyway, it's a list of like 10 proposed redactions. Is that the same thing when we get down to it, or?
No, I have.
Well, give me what it is that I need to be looking at.
I can find it and forward it.
You know what I'm looking at right now is not even about the jail calls, so never mind. But I don't have what it is that you're talking about. I'm looking for. So there are 5 jail calls, and there are portions of the 5. Is that right?
Yes.
Okay. And then you have agreement as to certain portions of those? Okay.
Yes, so the state's intention was to play the entirety of the calls, but
All right.
then there were some objections, and so
Sure.
we don't have any objections.
Okay.
We don't have objections.
All right, so do you want to put on the record what portions?
As if the court has the email, I can go through the areas where there was objection. And
I don't have the email. I do have the email. I just don't know where to find the email. Okay. All right. All right. I am now looking at the email. So go ahead.
So for the first call, which is on March 11th, 2015, there's an objection from 10 minutes and 45 seconds to the call to 10:50. And the state has no objection to not playing that portion of the call.
Okay.
From 15:15 to 15:32, the state has no objection to stopping, to not playing that portion of the call. For the June 10th call, from 7 minutes to 7 minutes and 3 seconds, we have no objection to not playing that portion.
Okay.
From 8 minutes to 8 minutes and 12 seconds, we don't have an objection. And from 9 minutes and 57 seconds to 10:15, we do not have an objection.
Okay.
For the June 13th call, we do object to that portion of 2:55 to 3:10.
Okay.
June 14th, we have no objection from 13:51 to 13:58. No objection from 14:11 to 14:13. And then for the June 15th call, we have objections to 4:53 to 5:11.
As in y'all want that in?
Yes.
Okay.
6:01 to 6:12, we object. We want that part in.
Right.
6:42 to 6:49, we want that in.
Okay.
But I don't know if someone told me this, but I wrote in 13:10 to 13:17. And we don't have an objection to that part. I'm not sure if maybe someone called me, but I wrote in another portion of that call, and we do not object to. Oh, that's on the email as well? Okay. I wrote it. I have it handwritten.
Okay.
So, Oh, because it's on the back side.
All right.
So we have no objection to 1310 to 1317.
Okay, great. All right, so then our issues are with June 13th, 255 to 310. And then June 15th, 453 to 511, 601 to 612, and 642 to 649. Is that correct?
Yes, Your Honor. And so we're pulling those two calls up now, Your Honor.
Okay.
As Mr. Box is here and Mr. Steele is handling this portion, may I step out?
Sure.
This is a free call from.
Here they come!
God, I hate the singing. Borderlands, rated PG-13.
My doctor just told me I have stage 4 prostate cancer.
Why wasn't it caught earlier? Now what will happen to me and my family?
The only thing worse than learning you have cancer is learning you should have been diagnosed sooner. Should your doctor have tested you earlier? Were you denied a potential cure because your doctor failed to act? If so, you're not alone. The Porter Law Group can get you the answers you deserve. Call 833-888-LATE for a free case evaluation or visit NY.
Hey, D-Shot come up and come meet you.
And that concludes at 3:11, Your Honor. And to give some context, on this call, this is a call from June 13, 2015, which is 3 days after that June 10th interview. Mr. Copeland is now in custody. He calls his girlfriend, Ms. Quarterman, who then calls the person who you hear is Max, but is also Dolly White, also known as Dolly White, but is Mr. Williams' sister.
Mm-hmm.
She is a person that the state alleges a number of the gang members will call to get in contact with Mr. Williams or for her to facilitate a number of different things throughout the trial.
Mm-hmm.
And while on the phone, there's first talking about money to help with his bond. That's
Mm-hmm.
when you hear her talking about meeting the girlfriend at the gas station.
Right.
Then he says, little D, it ain't right. At that point, they jump to, because he snitched, because he told on Roscoe, and they're talking about him not doing what a gang member is supposed to do, which is then snitching, Your Honor. So we believe that that is relevant information for this jury to hear, that the gang members are talking about the failure of another gang member to be supportive of the gang, to actually tell or snitch on another gang member. And that's what's contained in that portion of the call.
Okay. And the objection.
Hearsay, Your Honor.
it is not, I don't know, I've listened to these so many times, I don't know if it's fair to you, but he never said about, oh, this is what gang members should act like, this isn't appropriate for a gang member to snitch on someone. That's not in there. What he said is, something to the effect, I'm not quoting it, hear what little D did.
Yeah, and then she says, D ain't right, D done told, blah, blah, blah.
Yeah, so how does he know that? Who did he hear it from?
Well, I don't know that that matters because they're not offering it for the truth of whether D ain't right.
I don't know.
We are not offering whether D is or ain't right. It's the fact that literally it was everything they said about him, and overtly the fact that a YSL member they believe told if he did or didn't, and their anger towards it.
I just don't see it like that. I see this. This is after Mr. Copeland. This is after Mr. Copeland has cooperated with the authorities. He is in contact with Detective Gaither on a daily basis.
Yeah.
And he is speaking now as a government agent.
And do you have proof of that? I mean, that's not an issue in this trial. This is him on the phone with his people still thinking nobody knows he's said a word.
Of course, no one knows it. That's why he's an agent. The government. He is being told on June 10th, you need to work with us, otherwise you are going to get severe time. And he says, great, I will work with you. That's in the recording that you listened to. You didn't listen to that part, but it's in this 9-hour recording. So I don't see how this comes in. It is hearsay that he is just saying, did you hear with this other person? We have no idea the context. And it is being asked for the truth of the matter because that's why they are talking about it. This is not, oh, it doesn't matter if it's true or not. He's specifically saying this man said something. I don't see how that comes in. You know, we could ask him about it, but I don't see how the jail call comes in. I think the state has to lay a predicate or a foundation before you can just.
Well, I mean, I would assume they're going to have to lay some kind of foundation for some reason to get it in.
If they lay a foundation, then
And I don't know what that's going to be, but assuming, I mean, I don't know. Maybe you want to elaborate, Ms. Hilton.
We believe this is also evidence of the overarching gang conspiracy. Again, we have to prove that this is a conspiracy, that this is in furtherance of that conspiracy around. We believe that one YSL member telling another YSL member that one YSL member snitching is in furtherance of protecting the conspiracy, protecting the gang, Your Honor. And this would be evidence of that. So essentially it would be a co-conspirator statement between these co-conspirators talking about gang activity.
I mean, I think if the proper foundation is laid, that comes in over a hearsay objection. Okay, and then, excuse me, June 15th, a couple of different portions.
Your Honor, of course, I would just start at 4:50 and play through 6:49 because it's only about 2 minutes for those 3 seconds.
Hello, sitting on the phone.
And tell me who I'm about to hear.
Yes, Your Honor. And this is again Mr. Copeland calling his girlfriend on three-way, but at this point he has asked his girlfriend to call Detective Gaither, and so the portion that you're hearing is Mr. Copeland and Detective Gaither on the phone.
Okay.
I'm going to start at 4:47.
Like, I'm not going to sit here and promise you, like, you're going to get out of jail next week or in 2 weeks all that. Like I told you, you gave us a lot of good information, but we got to still do our job. We're not just taking your word for the gospel just because it's coming from you. We still got to investigate shit. So all of that will be taken into consideration at the end of the day.
So my brother,
like I said, do your brother know what?
That federal put the feds put charge him.
I'm not talking to nobody about your case, but to you and who you got on the phone. Yeah. That's up to y'all. Like we don't do that.
I'm saying, so is they trying to work with me though? Is they gonna try to work something out?
I can't say what they gonna do. Like I said, everything that you told us, we want to speak with you again. All of that will be taken into consideration. That's what she told what the ATF agent when we first came in, the lady.
Yeah. That's
what we did in the beginning. A lot of what you say will kind of determine your future. That's why you need to be completely honest with stuff.
Yeah.
So at the same time, we still got to look into it. We're not just going to take your word for everything you say. We got to be able to, prove what you say is true.
So if I prove it, then y'all let me have it right.
Are you hearing anything that I'm saying? Because I feel like I'm talking in circles.
Nah, I hear you, but it's confusing.
If you provide us with some things that we can verify, it's not up to us to let you out of jail. That's totally up to the DA's office, all that stuff on what they want to do with you. They do take into consideration if you helped or not. And so far, it appears as if you've helped, but we still have to do our job and investigate.
Yeah. So I still got state judge and
I conclude at 6:53.
Okay. And so what is at issue? What statements specifically are at issue?
Detective Gaither's statements, bolstering so far. You've helped. We still have to corroborate, but so far this was helpful. I don't know what the right word is. And I believe that that's bolstering his statements.
All right, and what does the state say to that?
Sure. Yeah, we don't know what he's going to say on the stand. But if he goes down the same line of, I was just lying to finesse investigation, I made it all up. This is in complete contradiction to that because she's telling him, just like she told him in the interview, we have to verify what you're telling us. So if he was telling lies, he wouldn't continue to say the same things over again because she keeps telling him, everything you told us, we appreciate you telling us, but we have to verify everything that you said. So there's nothing I can do for you until...
Well, he's not really saying anything over again. He's saying, hey, I told y'all something. Can you let me out now?
Right, and so when he's saying everything I said is a lie. So
he is now, yeah.
He is now. So what this shows is a contradiction because he wouldn't be calling the detective trying to continuously see if he can get out of jail if what he said was a lie. Especially when she's telling him.
All right. The objection is that Detective Gaither's statements, well, yeah, I mean, you seem to have helped us, but whatever. Why do you want any of this?
Well,
how do you envision using that particular thing I just heard?
So there's a few things. So part of this trial, some of the defenses that have come out is that the police didn't fully investigate anything.
Okay.
That they took his version and just ran with it.
Okay.
So this supports that that's not what happened. That even back in 2015.
Is Detective Gaither going to testify?
She has testified.
All right. Has she said already, man, we didn't just take his word for it, we investigated?
She testified
yes.
to that.
Okay, so it's not necessary for that.
But again, I think it gives context to, while Mr. Steele's focused on Detective Gaither, we're focusing on Kenneth's actions, that if he lied, he would not continue to call the police to verify how are they going to help him when he knows, listening to Detective Gaither, every time she speaks to him, she says, we can't do anything yet until we verify what you told us. So clearly what you told the police isn't a lie. Even though you're saying that today in 2024, what you told them back in 2015, you believe to be true because you wouldn't keep calling if you just wanted to tell them one lie and that was it. You wouldn't keep calling the detective.
All right. So let me ask you this. If what you want that in, or those portions in for, is Mr. Copeland's, hey, y'all, come on, I gave you the truth. Let me out now. Is there some way that you could redact that where we don't hear big chunks of Detective Gaither saying something she's already said on the stand anyway, which is, I got to verify this stuff? See what you can do, okay?
We can see what we think would be out of
Well,
we'll see.
I don't know.
Judge, if I may.
Yes.
Again, putting everything in context and thinking back to some of the testimony that Mr. Copeland had put forth previously. The state's position that they just put to the court as well. If he wasn't telling the truth, why would he call and try to follow up and see if they were checking on his truth or not? When he testified, one of the things that he said, it was probably the biggest thing that he said is, hey, they don't know that I'm lying. He said, yeah, I lied to them. I'm trying to finesse my way out of this, but they don't know that I'm lying. And that was in response to a specific question that Madam Prosecutor, Ms. Hilton, asked Mr. Copeland. So I think that kind of, that goes against what they're saying as their rationale.
I mean, don't get me wrong. I'm not sure that what they're saying it's going to come in for is going to in any way show or be a convincing argument, but I mean, they can. Yeah, it's not inadmissible for them to try it.
No, I understand. But I think our objection, as Mr. Steele stated a little while ago, is, why is any of what the detectives bolstering of Mr.
I understand, which is why I told her if she can come up with a way to get her part in without the objectionable part, she needs to try to do that.
I'm confident that she can.
Let's have it. All right. Okay, so that is all of the jail statements.
Yes.
Okay, super. All right, one thing I wanted to do is do some test run of this, and this doesn't need to be on the record, where I just don't have it. I've never used these before. So how is it that y'all are doing this? Do I hand these out to all of y'all and then? All right, I don't need to, y'all have them. So. Okay, and I mean, everybody doesn't have to do it. If a couple of people want to. I have no earthly idea. It's plugged in right now. Okay. So I take one of these too. Is there some significance to the red ones? Hey, is there some significance to the red ones? Does anybody know whether there's some significance to the two that are red?
I don't think you've ever used those.
All right, so. And does the court reporter get one so she can also hear what's going on, I would imagine? Okay. And then what?
There's a push to talk.
Sorry, y'all. Yes. We're done with court for the day, so you do not need to video me trying to figure out the technology.
That was the easiest request, Your Honor. Clarify that.